All right, welcome back. I'll look first to our court reporter, Ms. Cott. Are you ready to go back on the record?
Hello, I'm here and I'm ready. Thanks.
Great. Thank you very much. I will orient us once again and then we'll get started. Good afternoon. It's after lunch, 1:02 p.m. on September 24th. I'm Nicole Kinsey, the presiding hearing officer for the Administrative Hearings Office of the State Water Resources Control Board, and this is the hearing with respect, the water rights hearing with respect to the proposed Sites Reservoir project. We are reconvening after lunch. We had left off, we were still in cross-examination of panel 9, and we'll pick up there in a moment. I did have a couple of housekeeping issues that I was thinking over during the lunch hour that I think we need to return to, so I thought we'd deal with those. And then I will turn to Ms. Ingram, who I understand had a few more questions for this panel. The first issue I wanted to talk about was the order of witnesses for the coordinating NGO parties. And I know we had let's see, it was a September 19th email from Ms. Dorman. And I wonder actually if my best guess is that formatting may have been lost in the email transmission, because there's a list here of the NGO witness order, and it's not clear to me what it means and whether these are proposed as panels, because they all come out as just one long list to me. So maybe Ms. Dorman or another representative, can you describe to me the intent, whether there's an intent to put some of these witnesses on in panels? Um, what is I see Ms. Norris is listed first. And then
Yeah.
it says Monday, September 30th, and then there's a number of witnesses listed. And then again, it says Monday, September 30th. So I just wanted some clarity to make sure I understand.
I can speak to this, or Ms. Mertz can.
Great.
Go ahead.
Either way, Mr. Busher, you're
Sure.
welcome.
So, the first 5 witnesses, starting with Ms. Norris and then through Vice Chair Tayaba, are being presented as a panel.
Okay.
That'll be the tribal witnesses, interests, perspective panel. The next line there, which is Dr. Khan and Mr. Asarian, their report was drafted together, is my understanding, or there was one report from the two of them. And so they'll be testifying together as a panel. I think the only other group is the very last one listed, which is again Dr. Khan and oh, I'm sorry. The Dr. Khan and Mr. Asarian are listed twice because they have a scheduling restriction on the in-between dates. So if they don't go on the 30th, they'll have to wait until the week of, well, later in the proceeding.
Understood.
And then Mr. Resnick and Mr. Asarian submitted reports addressing similar subjects, and they may testify as a panel, but they'll be at the very end of the proceedings if they do that, and we'll figure out the answer to that far enough in advance.
Great. Thank
And
you.
then I think everybody else is an individual witness, like testifying by themselves.
That's helpful. And then I'll turn on that and wanting to get back to the collective is a fine answer. But Mr. Ferguson or Mr. Hitchings, do you have an estimate? And you may not have, I don't know if you discerned this email or had the same trouble I did, but do you have an estimate for for cross-examination for the first panel, which I understand is the first 5 witnesses listed here?
Yeah, I'd roughly estimate a couple hours for the tribal witnesses. May stretch a little longer than that. So 2 hours, excuse me, or a little longer than that.
Understood. And then panel 2, assuming we get to them, do you have an estimate for that? Which is
I'd say maybe 60 to 90 minutes.
great.
Yeah.
Does that help? I mean, we'll continue to get estimates as we go forward, but to the folks who are coordinating witnesses, does that at least help with the September 30th and October 2nd? Because I don't know, I don't think we're going to get through. I think the authorities case in chief is going to spill into September 30th. And so this will end up getting bumped back somewhat.
Yeah, I was just gonna offer, it seems to me that Khan and Asarian, we may get to them
Go
next
at the
Monday,
end.
but it seems
Yeah.
unlikely at
Yeah,
this
I
point.
think that's probably right now that we're thinking about it.
Yeah, and Dr. Swanson is traveling after the 2nd. If she has to testify after that, she can. She'll be available by Zoom to do that. We'd like to get her in before the 2nd, so that may move up a little bit depending on when the case in chief starts and how long that first panel goes. But we'll be prepared to have one of those next 3 witnesses ready to testify on the afternoon of the 30th if we can't get to the whole panel, or to be prepared to go as soon as they can if we skip Dr. Khan and Mr. Sarian the first time around.
Yeah, Ms. Kenzie, can I ask for clarification? When
Right, yes.
Mr. Busher says the next 3 witnesses, I just want to make sure I understand what his
Yeah, Mr. Stork, Mr. Schutz, and Dr. Swanson. So we'd like to have Dr. Swanson done by the end of the 2nd, and so that's the restriction there.
Okay.
So Dr. Swanson may move up earlier, well, before Mr. Schutz or Mr. Stork, depending on the timing.
Correct.
Yeah.
And yeah,
Okay.
I think by the end of today, hopefully we'll know a little bit more precisely where we are for the 30th.
Right. Thank you.
Yeah.
And then with respect to October 2nd, we had, I scheduled it as a hybrid day. And by scheduled, I mean, it was somewhat tentative, but I had to get the notice out. So I did do that. I don't know if you, Mr. Busher, or others can speak to whether you intend to have any of your witnesses in person or whether you expect they would all appear by Zoom. Do you know?
I don't. I'll defer to Mr. Stork and Mr. Schutz whether they would intend to show up in person if they're testifying that day.
I'd say most likely I would show up remotely.
Okay.
If Mr. Schutz is going to show up, I could do that as well.
I think Mr. Schutz said he was going to participate remotely. Did I understand that right?
Remotely would be my preference, but
okay.
Yeah.
And the reason I'm asking is not, frankly, it's so I can convey to the board members whether or not we're likely to have anyone in person, and then they can make an informed decision as to how they would like to proceed. So it's really just soliciting input. I appreciate
Yes,
that.
it's a little difficult to know what Mr. Mooney's available might be too at this point. Availability might be at this point. So that the safe answer is that we'll participate remotely.
Thank you. I appreciate that. Mr. Soderlund, I didn't mean to skip you. I saw your hand was up and now maybe it's down. Did you have a comment?
Yeah, sorry, had to get off mute. Eric Soderlund for the California Department of Water Resources. Just to throw it in, I don't expect much. I really like pretty firm, less than half an hour on all of the NGO witnesses. For me, I've not coordinated with the state water contractors. So very little
Less than half an hour in total?
in total.
Okay, thank you.
I guess maybe as you know, because we'll be going after the authority, that could go down. It could go up, but I don't expect I can commit not a lot of time.
Thank you. That's helpful. Ms. Cott, I'm sorry, do we need to provide some assistance?
Well, I would just it'd be very helpful if these witnesses, new witnesses, I don't have any kind of information on them. If somebody could email me what you guys are looking at, or for the next panels, that's always helpful to get those names in advance. And also for this transcript, I don't have any of that information.
Yes, I can ask. I'm going to virtually look to my team. If you would please email to Ms. Cott. I think you can just forward Ms. Dorman's email of September 19th, which has a list of these witnesses. That would be a good start.
Thank you.
Sure. All right, and then my last item was to confirm October 29th as our alternate date. I think we had left it at there, we needed to confirm witness availability. And I believe. And so I think the conversation I had was with you, Mr. Busher, but I don't mean to pick on you all the time.
That's fine. It was, I will get an answer to you by the end of the day before we
Okay.
break. And I'll make a note to re-raise that if it slips your mind.
Great, thank you. Those are the housekeeping issues I'd identified. Are there other things? Mr. Hitchings, please.
Yeah, thank you. And we can talk about these at the end of the day if you prefer. I think they're pretty quick. One was we just wanted to give an update on the request for record or exhibit citations to the Shasta Exchange arrangement. We will have an email go out to your office and the service list by tomorrow on that.
Okay,
So I
thank
wanted
you.
to just report back on that. And then maybe it's premature to raise anything with regard to rebuttal dates for the rebuttal hearing, but I've got a scheduling issue or, that affects obviously our team handling this for a couple of the days in January. And so, we can address that at a later time since people are digesting the schedule probably, but I wanted to just note that as early as it makes sense to do so.
Thank you, Mr. Hitchings. I appreciate that. Here's what I would ask is if you would please send in an email identifying the dates with the conflict. That way everyone can see it. And then I would invite other parties if you have, and these are really irreconcilable conflicts. There are so many of us. I know it's challenging to schedule days, but if you would please send them into our office and then we can find a time, whether we need to discuss that and think about a revised schedule. I can work on that. So I'd appreciate that, Mr. Hitchings. Thank you for bringing it up.
Okay, great. Thank you. Thank you. We will do that. And then just lastly, just on a point of order with the cross on this panel, and I guess going forward, I know you indicated that the Che Foca would have an opportunity to do some additional limited cross on those questions. But our understanding is the general practice will be one party will have its opportunity to do that for a panel and then move on to the next entity or party for cross. And we were a little unclear on the Save California Salmon cross. I think as well as yesterday, we understood that she was conducting the cross for Save California Salmon, but then Ms. Chicazola also did some cross today. I don't know if they were representing different entities. I thought they were both affiliated with Save California Salmon. We just don't want this to be something that would be repetitive with our last couple of panels, just to try to keep the order the way we've been doing it up to this point.
Thank you, Mr. Hitchings. I had not, and you're right, maybe I can look to, so first with I'll address with the Che Foca. My understanding there is we did, so part of the reason there is we did receive cross exhibits and then those didn't end up being used, and I understand that Ms. Ingram would like to address at least one of the cross exhibits. So I am going to allow that this time around. I think you understand that. But yes, going forward, I would like to hear from one representative in terms of cross-examination questions from each party to the proceeding. I will ask for clarification on Ms. Willie and Ms. Chicazola, whether both are with Save California Salmon. I don't know if either of them are online and can address the relationship there and who would be asking questions on behalf of Save California Salmon going forward.
I'm sorry, I was outside. I had something going on. I live in a rural area and someone came by. What was the question?
The question was whether you or Ms. Willie represent the Save California Salmon. Are you with different parties, the same party?
We're both with Save California Salmon and she is our attorney. She just wasn't able to be here. when she's not able to be here, I will be here.
So I guess the um, advice I'd give going forward is that I will ask that one of you engage in the cross-examination so that we don't have essentially a double cross. I know it's all coming out at the same time, but I just want to make sure, otherwise it's hard for everyone to keep track of when we're going forward. So going forward in this proceeding, if you would please coordinate, I mean, you can coordinate your questions, of course. I would appreciate that. That will help. There is enough going on as it is, as we all know.
Yes, of course.
Thank you. Appreciate that. Mr.
Hearing
Schutz, I see
officer-
you came off mute. Yes.
Hearing Officer Kinsey, in that regard, Mr. Mooney represents 4 different entities.
Yes.
There have been a couple of witnesses, I think, where he and I both had limited cross. I don't think that we've been unreasonable or inefficient in our cross. Certainly Mr. Mooney hasn't. I often bring a more technical sort of angle than Mr. Mooney, and I'd request that. I don't believe we're going to have more cross for the site's witnesses, but in the event that it comes up in rebuttal, I'd request the opportunity to, we could go sequentially or serially, but for both of us to do cross if that was something that we felt was appropriate in terms of content.
I understand that. I think we can work with that where there's the technical issues. And also Mr. Mooney as you pointed out, represents more than one party. So it's a little tricky. Mr. Stork, did you have something additional on that?
Yeah, I was going to say something similar to Chris. Sometimes there's particular expertise in one of the parties that may not be fully represented in the attorney representing multiple parties. So occasionally we may find it useful, and I think you as the hearing officer may find it useful if we judiciously sometimes have more than one person cross, not necessarily more than one person from a single party, but more than one party represented by a single attorney cross.
Yes. So here's what I propose. I think on this issue, not propose, I think this is what we should do. When it comes up just where one person is going to be cross-examining and there is going to be another person who would like to ask questions and who is representing the same party, let me know. And then Mr. Hitchings or Mr. Ferguson or vice, I guess it wouldn't go the other way. It's unlikely to, but then we can have a chance if we need to have a further discussion, we can do that. We'll also be on notice as to how many people we expect to have cross-examining and we're not doing a loop. Does that work for you, Mr. Hitchings? I mean,
yes, that sounds appropriate. Thank you.
Okay. I appreciate the problem, and I also appreciate both sides of the issue here. Ms. Chicazola.
Yeah, and I do apologize. I actually was asked to ask most of the questions I asked today on behalf of one of the tribes that's on our board of directors and is a party, but was unable to be here. But I should have notified you. And if that ever happens again, I will notify you. It's a very large time commitment to be here. So sometimes people do send us their questions. So apologies on not being clear.
I understand that. And are you in a position to identify which party you were representing today?
Well, I was representing Save California Salmon, but Winnemem tribe is on our board of directors, and a few of the questions were ones that they wanted to make sure were asked and put on the record.
Understood. Thank you very much. With that, are we ready to go back to panel 9? And I will look to Ms. Ingram. Are you ready at this time to ask your additional questions?
Yeah, but before I ask the question, I'll ask you a question. I want to make sure we don't do this again, cause any problems. Same with us. If we have a different person who's asking questions, do we need to let you know before today? We didn't know, honestly. We're not lawyers.
Yes, no, I understand that. Just let me know when we get to your opportunity for cross-examination. I believe I did And I may not have been clear. I believe I did ask earlier, and I just want to make
Yeah.
sure that I know if there are more than one who want to ask questions, that's fine. It's just understanding the ordering of things. So we know where we are in this process. So I appreciate that, but it doesn't need to be in advance. It just once we start the opportunity for Che Foca to cross-examine, if you let me know who will be asking questions, that would be helpful.
Sure, sure.
Thank
Thank
you.
you.
And
So,
you may begin, and if you need to bring up one of the exhibits, just let us know and we will do that
we
for you.
do have an exhibit, but before we pull up the exhibit, I want to ask the archaeologists two quick questions. One is kind of yes or no. Of the tribes that you did contact, because I know there are several who didn't, like ourselves, to your knowledge, did any of those tribes reach back around favorably to the sites project?
Do you mean by favorably to the sites project, do you mean favorably, they were favorable for the project?
Yes, exactly.
I don't believe that any of the tribes were favorable to the project. I'm going to turn to Ali and just confirm my answer. But
That's my recollection also. Yeah.
So none of the 14 contacted, or 13, I'm sorry.
Many of the tribes actually didn't respond to the contact. For those that did respond and that we have had conversations with, I would not characterize any of those as being favorable or like supportive, proponent or anything in that way of the project.
Okay, next question. And I'm trying to figure out how to say this, so the lawyers will probably stop me, but I'll do my best. Now that you know about us, and the word che'e, by the way, is salt, and foca is people. So that's our very foundation. But have you had an opportunity, having seen some of the literature or documents, to understand that there's some sacredness surrounded with the salt? It's not just a product. There are ceremonial prayers, if you want to. For instance, as a child, we were not allowed. We had cattle. We would ride over Salt Spring Valley all the way. We weren't allowed to gather any of that salt because we didn't know the prayers. And some of our friends from other tribes do. But I mean, are you aware of that? And would that make a difference in your opinion about now am I asking too many questions about the salt springs that are in the footprint?
I would say that I was not fully aware of the spiritual nature of the salt springs. It does not surprise me at all to hear that. I think as far as changing or altering our proposed, mitigation and management measures, I think it wouldn't alter those because those already include ways to coordinate with the tribes that have interest in particular areas. Throughout our process, we did collect or hear that we know there are important places, right, across the project footprint. We did not get a lot of detail on particular individual places. So it does not surprise me that to hear that the salt spring is an important place that needs to be considered. And I think that our mitigation measures and the authority's intent is to consider those as part of the project implementation.
I'm trying to absorb everything you just said. I think what you said is no, it wouldn't make a difference.
Correct. No, I think our mitigation measures have flexibility to account for significant places, and to coordinate with the tribes on how to address those places as part of the project implementation. Yes.
Having said that, would you agree that if you had contacted my tribe, you would have this information in full, probably lots of information, and that might have helped you to understand it more fully?
Yeah, that's
Speculation calls
absolutely.
for speculation.
Yeah, Ms. Ingram, that is a it would,
Okay.
Ms.
All
Rizzi,
right.
but she can testify as to anything that's factual that's happened, just not
Okay.
speculation about the future.
Okay, I get it. Can we pull up the document, please?
And which one? I think we have two. Pioneer.
Yes, I'm just gonna. The other one is real detailed, so I don't want to take too much of your time. We'll do this one. The Pioneer, the Calusa.
Yes, we may just need a moment to
sure.
bring it up.
Thank you, whoever's behind the scenes doing this. I appreciate
Ms.
you.
Mullen, she's
Ms. Mullen. Thank you so much.
There we go.
Okay, can we go to the bottom of this article, please?
Well, can we just for a moment, I'm sorry, Ms. Mullen, can we scroll back up just to orient ourselves to what this
sure,
is?
sure.
That would be great.
Sorry.
And is this, Ms. Ingram, can you describe to me where this came from?
This came from a local newspaper. It's quotes Jerry Brown, not the former governor, but the head of the Sites Authority, and his comments. I'm having trouble reading it. Sorry.
And so this is the Calusa County Pioneer Review, a local newspaper,
exactly.
And it looks like September 20th, 2024. So that's quite recent.
Thank you. Yes.
Yes. Okay. Now we can scroll down. It sounds like you wanted to go near the bottom, the end of the article.
To the bottom. Okay. Did we get to the bottom? Yeah, I think. Okay. Last paragraph. Can I read it, or it's short? Is it okay if I read it?
Please go ahead.
Okay. If constructed as currently designed, the site's reservoir would be the 8th largest in California, but could later be expanded to more than 3 million acre feet if the need, desire, and funding existed, Brown said. This is is he the chair of the Sites Authority? I don't know the right terms.
He is our executive director.
Okay. So what he's stating is when this starts from however many acre feet, which isn't even close to 3 million acre feet, that it could expand to this. And I think I don't know if it's 2 or 3 paragraphs up, eminent domain could be used, which we understand. But 3 million acre feet, where does that push what are the boundaries of that?
This is Ms. Forsythe. I was at this meeting, at this September 12th community meeting in Maxwell. We held this meeting to continue to reach out to the local community in the project area, or I should say, in the Maxwell area in Sites Valley. I believe the reporter misunderstood on this. I do not recall and feel very comfortable that Mr. Brown did not say that we would later expand the reservoir to 3 million acre feet. We talked about how the sites, we talked about how the Calusa Reservoir was a concept proposal previously by DWR, and that reservoir was envisioned to be a little over 3 million acre feet, but that Sites Reservoir is only 1.5. So I believe the reporter that wrote this may have misunderstood the conversation. I don't believe Mr. Brown said this directly as though it was a quote. That is not, we are not envisioning expanding the reservoir in any way at this moment, and especially not to 3 million acre feet.
So is that your statement that this is incorrect? Can we assume that then that this is incorrect, and you're saying that that's not been discussed?
I feel very comfortable testifying that this is incorrect.
Okay. That's all I have.
Thank you, Ms. Ingram. With that, I will turn to the Delta users. I believe you had indicated at least previously that you had a few questions. Mr. Reese, I see you. Do you still have questions for this panel?
I do not have questions for this panel.
Okay, thank you. With that, I will turn to Mr. King. There you are.
Yes.
You had some questions related to there were specifically related to Zone 3. I realize we had this conversation before. I'm going to go ahead and give you a few minutes to ask those of these that you find important. I will exercise my discretion to try to keep us focused, but I will hand it over to you if you have questions for this panel.
Great. So, Ms. Forsythe, you remember we had discussion regarding the formation of Zone 3 in the panel 1 discussion, I believe it was August 27th.
I do recall that, yes.
And so I think it was stated that currently Zone 3, which is formed in the Colusa County Flood Control Water Conservation District, is an associate member of the Sites Authority.
I believe that's either what Mr. Brown or Mr. Robinette testified. I honestly am not that super in tuned to their exact membership.
Okay. Ms. Mullen, can we bring up King 51, Exhibit King 51? And let's make it a little bit smaller. Shows the full page, right? And a little bit smaller, please. Yeah. Okay. Do you recognize this this exhibit that I brought up in panel 1, Ms. Forsythe?
I do recognize the exhibit. I honestly don't think I've read through it before, but I do recognize that it's the resolution that forms Zone 3.
And the signature is Gary Evans sitting as chair of both the Colusa County Board of Supervisors and Colusa County Flood Control Water Conservation District.
That's what the document states, yes.
Right. Ms. Mullen, can you just go to the next page? And can we rotate this again? To be I guess let's go. Right, there you go. Good. And then can we zoom in? And Ms. Forsythe, you remember? Do you remember that this is the current map of Zone 3, which includes Quetzaldehi, Winton Nation Rancheria?
That is my understanding of what this is, yes.
And you also recognize that it's a sovereign nation, Quetzaldehi is.
Yes.
Okay. And so in your testimony, you had some conversation, you actually explained some of the context for why Quetzaldehi was included. Do you remember can you restate what your reasoning was, why it was included?
Objection beg.
Okay.
What?
Do you remember stating that to your knowledge, that the Sites Authority has not reached out to Quetzaldehi about its inclusion in Zone 3?
I don't recall that specifically, although I could have very well said that. Zone 3 is not we Sites Authority are not Zone 3. It is a separate entity and organization, although they are potentially either an associate member, potentially in the future, a full member of our reservoir committee. We are separate entities between the two. So to my knowledge, the authority has not reached out to Quetzaldehi on its inclusion in Zone 3, but there would be no reason why the authority would do that.
Knowledge, nobody at the county has reached out to Zone 3.
I can't
Objection
speak.
calls for speculation.
Okay, and so, but do you remember stating that your understanding and conversation with the county of Colusa that Quetzaldehi was included because there may be water provided to Quetzaldehi at some point in the future?
So we, at the Sites Authority, myself, personally involved in this, worked collectively with all of our reservoir committee members to develop what's called our place of use that we submitted in our water right application. This is separate and distinct from questions around Zone 3, and is talking specifically about the authority's place of use. Myself and Ms. Bizzoni had a number of conversations with Colusa County to refine the place of use in Colusa County. And we specifically included Quetzaldehi and the authority's place of use in our water right application, because at the time the county expressed concerns that Quetzaldehi, my understanding and recollection was that their water supply is poor, and the county was considering poor, meaning of poor quality and not very much in quantity. And the county was considering ways to try to help the tribe and provide opportunities for the tribe in the future to receive water from other sources that could help the Quetzaldehi. So that is why the authority included Quetzaldehi in its place of use in our water right application, but I really can't speak to why the county included it in Zone 3.
And was there any discussion about when such water may be provided? What year, what period after construction is completed?
I don't think there's any firm commitment from the county to provide water to Quetzaldehi. I shouldn't say that. I am not aware that the county has a firm commitment. I simply understood that the county wanted to make sure that the tribe could receive water out of Sites Reservoir, and so wanted to make sure that they were in the Sites water right application place of use. But I can't speak to any commitments made between the county and Quetzaldehi. My impression was that the county just wanted to make sure that Sites water could be used on the reservation, on the nation.
Do you think the county knows that the site's water probably will have too much mercury for human consumption during the first 10 years?
Objection calls for speculation.
Okay, so I'll finish up then. Is this inclusion going to be include Zone 3 as it's currently formed with Quetzaldehi? Will that be presented as part of the WISIP the WISIP application to get state funding under Prop 1?
So the WISIP application was submitted a number of years ago, and the authority has not stopped funds for providing water to disadvantaged communities. I don't know if that was even a benefit category included in WISSIP.
And then on the WIFIA funding, do you know if there's any preferential funding if you have a tribal nation within a service area?
I don't know offhand.
Okay, great. Well, that's all my questions. Thank you very much.
Thank you, Mr. King. And I believe with that, we have completed cross-examination of this panel. So I will look to you, Mr. Ferguson. Do you have redirect for these
Yes.
two witnesses? Please go ahead.
Ms. Forsythe, do you recall questions yesterday regarding the authorities' efforts in Glenn County?
I do, Mr. Ferguson.
So do you recall responding that the authority hadn't conducted any work to date in Glenn County?
I do recall that.
And since the hearing yesterday, have you had an opportunity to kind of refer to your notes and kind of refresh your recollection with respect to the authorities' activities in Glenn County?
Yes, I have. I went back and refreshed my recollection on this just to make sure. And I did find that the authority has actually conducted some geotechnical investigations in Glenn County. These consisted of what we call geotechnical borings or drillings in roadways. This work was conducted from September of 2022 to December of 2022. It did include tribal monitors, and this work was conducted prior to the Paskenta tribe expressing an interest in the project, which occurred in March of 2023.
Great, thank you. Ms. Forsythe, do you recall questioning by Dr. Curdy yesterday when he referred you to and read from an April 2023 letter from CICC regarding certain content they may request to be considered in the site's project EIR?
Yes, I do.
And do you recall testifying that you had verbally requested that content from CICC during meetings with CICC between April 2023 and October 2023, but you were not able to recall specifically which meetings when that occurred?
Yes, I do recall that.
So since testifying yesterday, were you able to refer to anything in the record that refreshed your recollection regarding those meetings when the authority verbally requested that information?
Yes, I was able to. Ms. Mullen, if we could bring up Sites Exhibit 95. And then page 502, please. And down towards the bottom of the page. Yes, so this last paragraph on the bottom of this page and rolling into the top of the next page identifies that the authority, identifies that the Calusa tribe stated at their April 18th and June 15 meetings that they would like to include information in the final EIR EIS, and that information was to be included in the form of a statement from the tribe that the authority would not change in any way. This identifies in that third sentence that says, we stated that we would include information provided by the tribe in the final EIR EIS and asked for this statement. If we scroll to the next page, sorry, Ms. Mullen, if you could just go back up really quick. The paragraph also identifies that we asked for the statement again at our October 2nd meeting with the tribe. And now Ms. Mullen to the next page. At the end of the paragraph there, we identify that as of the writing of this letter, which was October 20th of 2023, that it was already, in fact, too late to include the document in the final EIR, as the final EIR was in its final production stage. And we identified that if we receive the statement no later than close of business October 27th, 2023, the authority would include it in its CEQA administrative record, and include it in its board packet so the board could receive that statement, which we did in fact do.
Okay, thank you. And just to clarify, this language is included as within an attachment to a letter from Executive Director Jerry Brown to Chairman Mitchum, correct? That's dated October 20th, 2023.
That is correct.
Okay, thank you very much. That's all the questions I have.
Thank you, Mr. Ferguson. I will then look to the room for those who have not participated in recross. The scope of any questions on recross examination must be within the scope of what we just discussed based on questions from Mr. Ferguson. So it is a much more limited scope. I see Dr. Curdy. Do you have recross questions for these two witnesses?
I do. Can you bring up that exhibit that was just up, please? What is the date of this letter? It says it's a response, correct, to Calusa's September 29th letter. What's the date of this letter?
Ms. Mullen, if you scroll up to PDF page 497. This is a letter dated October 20th, and that is an attachment to this October 20th letter.
Okay, can you scroll back down to where we just were, please?
That was 504.
Thank you.
I think it was actually
sorry,
502.
502. Sorry, my apologies there. Yeah. Sorry, Ms. Mullen.
So, Ms. Forsyth, Mr. Ferguson, a question to you both. It states April 15th and June 15th meeting, that this was discussed at both the meetings. You understood CICC's position, and you stated you would include information from the tribe. Is there any memorialization in anything else regarding the April 15th or June 15th meetings besides this letter from October 20th, where CITES states that they will include the letter in the form that the tribe requested?
I would need to refer back to previous correspondence between the time of those meetings and the date of this letter to confirm that.
So with your current understanding, just so I'm clear, you are not aware of any other memorialization of this in any written communication or consultation?
That is, I don't believe that's what I said. I said I would need to refer back to take a look. I will also state that the third sentence in this paragraph states that we identified at both of those meetings that we would provide the information and asked for the statement.
And because I was at those meetings and I do not recall this request ever being made, this is why I'm asking you the question to provide the memorialization of this in any other document than an October 30th letter, or sorry.
Dr. Curdy, you've asked this
yeah.
question. I
Okay.
think this is the third time we've asked the question.
Yes.
I understand you don't agree with the response, but it's been asked and answered.
Yeah. So this letter dated October 20th when did the letter come from the tribe?
Objection vague.
This request put in here in what we're looking at right now on October 20th, did the tribe send you the letter within 7 days and within the deadline of what you stated was October 27th?
Miss Mullen, if you go to the top of the next page. So yes, the authority did identify that it was already too late to put the document into our final EIR, EIS. But if it was received by October 27th, we would be able to put that into our record. And we did receive it from the tribe, I believe, on October 27th.
Okay. So do you find it curious that the tribe was able within a week, when you identified that you would accept it and you gave a deadline, that the tribe provided this information within that time frame?
Objection vague and argumentative.
That's fine.
Okay.
That's fine. We look forward to you identifying further in the memorialized record where these statements were made. That's all.
Are those all your questions, Dr. Curdy?
Yeah, are we finished? As long as we're finished with anything on the Calusa tribe front, yes.
For this panel, I mean, yes.
Yeah, that's what I mean with this panel.
Yeah.
Yeah.
I will look to the room. Does anyone else, I'm going to just go as a group, please raise your hand if you have additional questions for recross within the limited scope of the issues Mr. Ferguson raised. All right, with that, I want to thank both of you very much for your time and efforts today answering all these questions. Well, not just today, over the past 2 days, answering all of these questions. I really appreciate you being here and joining us. I believe with that, we are ready to move to panel 10. Is that correct, Mr. Hitchings and Mr. Ferguson?
Yes, we are. And our colleague, Michelle Chester, is going to be the lead for this panel. So she should be joining us momentarily.
Great. I mean, if we need to take a break.
Yeah, let me confirm that.
Oh, she's in the waiting room. She's here. All right, I believe Ms. Chester, welcome, first of all. And it looks like, why don't we go ahead and take, will you actually just please identify who your witnesses are for this panel? I don't have it in front of me. And then we'll make sure everyone is here. Let's do it that way.
Panel 10 consists of Kevin Spessert and JP Robinette.
And it looks to me like both of you are here. So with that, Ms. Chester, are you ready to proceed with panel 10? And if so, I will go ahead and swear in the witnesses.
Yes, thank you.
Thank you. And I know, Mr. Robinette, we've seen each other before, but if you would please, we'll go through this process again. Mr. Robinette, Mr. Spessert, please raise your right hand. Do you swear or affirm under the penalty of perjury that the testimony you will give in this hearing will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you very much. Please go ahead, Ms. Chester.
Thank you. For Ms. Mullen's benefit, I'll just note that we are going to be relying on presentations contained in sites 272 and sites 274. The purpose of this panel is to address hearing issue question 3E and related questions of land acquisition and facilities access. As a reminder, Mr. Robinette was a participant of panel 1. In accordance with the hearing officer's prior instructions, I am not planning to ask him again to confirm the accuracy of his written testimony and exhibits.
Thank you.
Okay, Mr. Spessert, would you please state your full name for the record?
Yeah, Kevin Michael Spessert.
And do you understand that you are presenting your testimony under oath?
Yes, I do.
Is exhibit sites 12 an accurate statement of your written testimony?
Yes, it is.
And did you prepare that written testimony?
Yes, I did.
Do you have any corrections to that testimony?
Yeah, I have a minor correction. It's page 2, line 22 and 23 of my testimony. I listed percentages of parcels to be acquired for construction for the project within Colusa, Glen, and Yolo counties. Collectively, those percentages exceeded 100%. The correct percentages should be 75% in Colusa County, 15% in Glen County, and 10% in Yolo County. And the percentages are reflected correctly in the summary presentation, which I believe is Exhibit 274 on slide 5.
And do sites exhibits 13 through 16 submitted with your written testimony contain true and correct copies of documentation of sites authority governance documents and project area parcel maps?
They do.
And is it exhibit 274, excuse me, sites 274, a true and accurate summary presentation of your written testimony?
Yes, it is.
And at this time, would you please summarize your written testimony relevant to the topics you are covering on this panel?
Yeah, absolutely. Just bring the slides up, please.
Again, this is sites 274. Thank you.
There we go. Thank you. All right, thank you. Good afternoon. My name is Kevin Spessert, and I'm the External Affairs Manager for the Sites Project Authority. My presentation today will summarize my testimony regarding the Sites Project Acquisition Program. Next slide. Today we'll talk a little bit about our real property and land management policy, the land needs the land that is needed for project purposes, the authority's ongoing landowner coordination activities, and the authority's early land acquisition program. Next slide, please. As the Sites Project Authority's External Affairs Manager, I serve as one of 4 authority agents working under the Executive Director, colleagues with Ms. Forsyth and Mr. Robinette, and I've served in this role since 2017. My areas of responsibility including leading the authority's federal and state government affairs team, the communications team, as well as the real estate and land management team. The authority's real estate and land management team is responsible for the authority's engagement and coordination efforts with landowners who are affected by the project, working with those landowners in an attempt to secure temporary rights of entry to conduct technical field studies, the acquisition of real property, including fee title acquisitions and securing temporary or permanent land easements needed to construct the project, and the management of lands that are ultimately acquired by the authority in the future. Next slide. The authority currently does not hold title to any of the lands that are necessary to construct the project. However, the authority does have the power to acquire the lands necessary as established in the authority's joint powers agreement in accordance with its bylaws. As part of that, the authority has developed a general set of policies and procedures that will govern the authority's future acquisition program. And that was established by the real property and land management policy, which was adopted by the authority back in May of 2019, which received minor revisions that were adopted in May 25th of 2022. This policy governs the project's current real estate activities and provides the general framework for the future acquisition program when the authority gets into the acquisition phase of the project. Next slide. The authority anticipates that there will be a mix of full and partial fee title acquisitions. Partial acquisitions would include acquiring portions of landowners' property for project purposes where the landowner will retain the remaining lands. Partial takes kind of definition of what those partial takes would look like. The authority also anticipates several permanent easements and temporary construction easements that will be necessary for the projects. These permanent easements will be on lands that are generally above or adjacent to project facilities or improvements, such as pipelines, that will remain in the landowner's possession, but will be encumbered with an easement that would provide the authority access for maintenance purposes over the life of the project. Temporary construction easements are generally associated with roadway construction activities, such that once the construction is completed, those lands are fully reconveyed back to the underlying landowner. There are approximately 250 parcels covering roughly 15,000 acres that would need to be acquired for project purposes. As the project design is finalized, the total acreage and number of affected parcels that need to be required become more defined. About 75% of those lands to be acquired are located in Colusa County, with 15% in Glenn County and 10% in Yolo County. Next slide. For many years, the authority has implemented a landowner coordination program that focused on landowners who would be subject to land acquisition for the project. This effort has really proven critical to the project's development. Feedback received during these activities has helped the project to refine the project's design, help to identify design solutions and operations that would seek to minimize the project's impact on landowners' property. As part of this engagement effort, the authority has held regular landowner meetings, most recently being in July of this year, July 17th in Maxwell for landowners in the Reservoir area, footprint area, and on July 18th in the Dunnigan area for landowners affected by the Dunnigan pipeline and the Colusa Basin drain. These meetings include landowners landowners whose lands would be subject to a fee acquisition, permanent easement, or temporary easement for construction activities, and represents about 280 landowners. Notifications for these meetings are sent via direct mailer utilizing the public available information from the Colusa, Glenn, and Yolo County Assessors Parcel Database. In addition to the general landowner meetings, the authority conducts one-on-one meetings with individual landowners to address their specific issues and concerns. These issues in these discussions, the authority talks to the landowners about how the project will affect their lands and what lands the authority will need to acquire from them, the project schedule and timeline, and the real estate acquisition process as it directly affects their parcels. Discussing the landowner's rights and benefits as part of a public acquisition process, and discuss regarding securing temporary right of access to conduct field studies if field studies are necessary on those properties. This process allows the authority to work through these issues with these landowners in a timely manner and gives them lots of time to consider all of their options as we advance toward the acquisition phase of the project. Next slide. In 2023, the authority authorized the creation of a limited early land acquisition program that focused on acquiring key parcels associated with key project infrastructure that are on the critical path for construction. Acquiring these parcels now ahead of the general acquisition phase of the project allows that vital engineering, geotechnical, and environmental fieldwork to advance on these parcels and prepare these parcels to start construction as soon as the authority reaches the construction phase of the project. These lands include parcels associated with Golden Gate Dam, the Sites Dam, and the Maxwell Sites Road Detour and the ultimate Maxwell Sites Road realignment. The authority is currently under negotiations to acquire these key parcels. However, under the current schedule, the general acquisition phase of the project would not begin until early 2026. Next slide. And that concludes my presentation.
Thank you, Mr. Spessert. Mr. Robinette, would you please state your full name for the record?
Yeah, I'm John Pepper Robinette.
And do you understand that you are presenting your testimony under oath?
I do.
And at this time, would you please summarize your written testimony relevant to the topics you're covering in this panel as set forth in Cites 272?
Absolutely. Yeah, if we could pull that up. And I had one presentation covering a couple of topics, so I'm going to start on slide 2 today. Just for those of you who weren't at my first panel, I'll just do a brief introduction. It's an honor to be here today to speak about the Cites project. I am John Robinette. I go by JP. I'm a licensed mechanical engineer, and my experience is in the management of engineering and construction projects, mostly in the water resources space. My experience covers the full range of engineering project delivery services, from design through project construction, department leadership, and executive assignments, and I've served the authority since 2019. I have a more comprehensive CV. It's in Cites 211. And now I'd like to move on, please, to slide 9. So I have a pretty short presentation today, but it's going to focus on the partner facilities and our related agreements on sites project, which I have been in charge of for the last 3 years. Next slide. So this diagram is useful in building understanding about how sites works within the existing infrastructure in the area, a lot of which we actually saw on our site visit that I was able to attend. So in this diagram, double lines represent existing facilities and single lines represent new project facilities. Where the authority is going to enter into agreements with others for the use of existing facilities, we've called those facilities our partner facilities. Generally, agreements to use these facilities are referred to as facilities use agreements. The project requires the shared use of existing facilities owned by Glenn-Colusa Irrigation District, along with the existing facilities owned by Reclamation and operated by the Tehama-Colusa Canal Authority, or TCCA. That includes existing fish screens, pump stations, canals, and regulating reservoirs to provide the conveyance of sites water into and out of the reservoir and from the river and back to the river. Approximately 88% or 165 miles of the conveyance infrastructure the authority plans to use for the project consists of existing facilities. Partner facilities also just refers to any facilities used by the authority that are owned or operated by another entity to convey water. So specifically here, the facilities required for the use of the sites project include those that are owned by Reclamation and operated by TCCA, starting with the Red Bluff Fish Screen and Pumping Plant, the Tehama-Colusa Canal, and Funk's Reservoir. Owned and operated by GCID are the Hamilton City Fish Screen and Pumping Plant and the GCID Main Canal. We have our facilities use agreements, which I've mentioned, which are for the long-term use and operations of these facilities in conjunction with sites. And then it's expected that for any capital improvements that might be needed, the authority would enter into design and construction agreements with our facility partners. That will be done at a later date. That work is generally, though, identified in the EIR and includes, for example, the 2 additional pumps at Red Bluff or the new check structure at GCID, just for a couple of examples. The project also requires the use of the Colusa Basin drain south of Ballston Weir. The Colusa Basin drain is a drainage canal owned by individual underlying landowners, which include RD 108 and other entities, both public and private. The authority refers to this area as the Lower Colusa Basin Drain System for the purpose of the sites project, and a map was developed and included along with an adopted resolution, which is number 2023-01, which we included as Sites 221. And that resolution has really directed staff's interactions with the interested parties in the lower CBD system. And I would say generally that system on this diagram is represented by items with the 2 purple lines. So I'm going to move to the next slide. And this is my last slide. So the authority has entered into cooperative agreements with local agencies to assist in the development of facility use agreements, which have been determined to be important for our participants as they make their decisions about the project moving forward, given the reliance on existing infrastructure. So those are commitments with Glenn-Colusa Irrigation District, Tehama-Colusa Canal Authority, and Reclamation District 108. We have existing cooperative agreements with those folks. And then the authority does plan to continue to work with Reclamation on any necessary conveyance agreements, such as a Warren Act for moving non-CBP, non-project water, and any real property agreements. That concludes my remarks on this subject.
Thank you, Mr. Robinette. And that is the end of Sites Direct Examination for Panel 10.
Thank you very much, Ms. Chester, and thank you to both of the witnesses. I will look first to the coordinating NGO parties. Mr. Busher, do you have questions for these witnesses?
Very briefly, less than 15 minutes, I would imagine.
Great, please go ahead.
Mr. Robinette, it's good to see you again. Thank you again for being here and for offering your testimony. Mr. Spessert, is that how I say that?
Yes.
All right, Mr. Spessert, my name is Eric Busher. I'm the managing attorney at San Francisco Baykeeper, one of the protesting parties in this action. Thank you as well for being here. It's good to meet you this afternoon. I just got a couple questions for each of you. Mr. Spessert, in your interactions with, well, actually, let me back up so far. You referenced there's 250 parcels, roughly 15,000 acres that are required for the authority to construct the project, correct?
Correct.
Okay, and then you referenced a couple of slides later that there are approximately 280 landowners that you've been reaching out to in contact with, something like that. Can you just explain the relationship between the 280 landowners and the 250 parcels?
Yeah, we expand out when we schedule, when we do our landowner meetings, a little broader group of landowners, particularly landowners who aren't necessarily subject to an acquisition, but may be affected by like roadway improvements to county roads, that we may not necessarily buy a land right as part of our program, but may be affected by any improvements that are done on county roads, just to make sure that they're a part of the discussion and we can solicit their feedback.
Okay, thank you. That helps. And for the 250 parcels, those are the parcels that are going to be inundated or nearly inundated. Is that correct?
It's a portion of them are the inundation parcels, either fully inundated or partially, as well as any acquisitions that take place outside of the reservoir footprint for any of the other facilities that are outside. So it could be roadways, it could be pipelines, but typically those are partial takes or easements.
And do you have a estimate for what proportion of those 250 parcels are going to be fully or partially inundated?
Estimate about 140 of those parcels are within the reservoir footprint, and those are represented by about 50 landowners. That includes the town side of sites.
Okay. And in your discussions with landowners thus far, are landowners typically represented by counsel in those conversations?
We have not had conversations with landowners where counsel has been present. Outside of some of the discussions that we've had on these early acquisition programs, where we're actually talking about acquiring ground, a couple of those landowners have had their legal counsel participate in those discussions.
And for again, thank you for the delineation. For the ones where you're talking, have discussed acquisition or are in that portion of the process, in the early acquisition phase, do you encourage those landowners to seek legal counsel?
Absolutely. Absolutely.
Thank you. I think that's all the questions I have for you, Mr. Spessert. Mr. Robinette, I just have a couple of questions about the fish screens and the partner facilities. Does the sites, well, who controls the maintenance and of the fish screens that currently exist that sites will be using?
Sure. The Tamakusa Canal Authority maintains the Red Bluff fish screen and pumping station under contract to Reclamation, who is the owner of the facilities. TCCA has a operation, maintenance, replace, and repair contract with Reclamation. And then as with regards to GCID, the Hamilton City Fish Screen and Pump Station are owned and operated by GCID.
And does the site's authority have any control over the maintenance of those fish screens going forward?
I think that any control we would have would be, really related to things that were negotiated through agreement, but generally no. And we don't have agreements yet, so it'd be speculating to say, but I don't anticipate so.
Well, the site, with the same question with respect to the ability to replace those fish screens, does site's authority have any control or involvement in that?
Not at this point.
And none of the, what's the status of those I don't know, operations, whatever we call them, agreements with the partner facilities?
Yeah, I mean, really, the process, we have entered into cooperative agreements basically to kind of collectively work on them together, and to provide the right resources to analyze different wheeling rate schemes and or I should say formulas and potential approaches to make sure that our partners are fairly compensated and things like that. But we do not have existing drafts of agreements. There's just been general discussions around what those agreements might look like. And most of the focus has been on the technical work to ensure there's capacity available for the project, that we wouldn't harm their existing customers and things of that nature. So it's been rather policy level and then technical.
And the cooperative agreements that you're referencing, those are in the record as sites. I believe it's 218. Is that right?
Did you guys lose me for a second?
Oh,
do you still
we might
still have me?
We still have you.
Okay. Oh my goodness. Okay, I'm looking right now. It is. They should be in the record.
Mr. Busher, did you suggest sites 218? Is that
I
what
think
you
it's 218, and it's in your testimony at paragraph 22, where I think these are described.
Okay.
I want to make sure I'm looking at the right stuff when I go back to this.
Yes, you're right. I mean, that's what it says in my testimony. I'm not pulling up the document yet, but that's the one with GCID and TCCA. There's a separate agreement with RD 108.
Okay, thank you. And then in terms of the partner facilities, am I correct in understanding your testimony that does not include Keswick Dam or Shasta?
You are correct.
That's all the questions I have for these two. Thank you very much. I appreciate both of your time.
Thank you, Mr. Busher. I'm looking to the room. Are there others from the coordinating NGO parties who have questions for this panel?
Ms. Kinsey, I have one or two questions for Mr. Spessert.
Please go ahead.
Good afternoon, Mr. Spessert. My name is Chris Schutz. I'm the Executive Director of the California Sport Fishing Protection Alliance, one of the protestants in this proceeding. Mr. Spessert, do you have any tentative agreements with any of the landowners for future purchase of their land should the reservoir project go forward?
Outside of what we're working on for the early acquisition program that are going on right now, those negotiations are going on right now. We don't have a purchase agreement in place for any of those yet. They are under negotiation. Outside of those, there are no purchase agreements for any parcel, any other parcel.
And Mr. Spessert, if you were unable to come to agreement on the terms of an acquisition with a landowner, you would implement eminent domain proceedings. Is that correct?
The authority, Sites Project Authority, has the ability to exercise eminent domain should it need to. I would say that the authority has worked very hard to try to avoid that, but it is certainly something within the authority's authority to do.
And you told Mr. Busher that there were approximately 140 parcels within the reservoir footprint, and out of a total of approximately 250 parcels in the project area that you were talking with landowners about. Is that correct?
Yeah, those are the approximate numbers. Yes.
And of those 250 parcels, how many of those would need to be fully acquired in order for the project to go forward?
Oh, I don't have that number in front of me. Of those 140 that are in the reservoir footprint, portion of those are partial takes along the high water side of the project. I would say that the vast majority of those 140 parcels would be full acquisitions in the inundation area.
And by the high water side, do you mean generally the east side of the reservoir?
I'm sorry, the high water line around the reservoir itself, kind of those properties that kind of go over the top of that boundary where some of it would be inundated and some of it.
And do you anticipate that some of the acquisitions will be partial? In other words, you'll acquire part of a parcel and not all of the parcel, or will you acquire all of the parcels that you acquire, in the parcels in their entirety?
I think it'll be unique to each individual land operations that landowner is currently under. Most of that ground is being used for cattle grazing. The authority will work with each individual landowner to identify if there are remnant parcels that are uneconomic, that the authority could acquire those based on kind of the needs of the landowner. If the landowner would wish to continue to own those remainder pieces, they could do that as well. It's going to really be, I think, an individual discussion or an individual approach to each individual landowner. Everyone is unique, everyone is different in what they want to do with the remnant parcels.
Thank you. Referring to the Dunnigan pipeline, how many parcels are we looking at that would be affected by the construction operation of the Dunnigan pipeline?
You know, I don't have that number in front of me. If I trying to remember back, it's along the Dunnigan pipeline itself, from the end of the Dunnigan pipeline to the Colusa Basin drain. I would say it's no more than 25 parcels.
That's all I have. Thank you very much.
Thank you, Mr. Schutz. Anyone else from the coordinating NGO parties? I will look specifically to Dr. Curdy, if he's still on. Do you have questions for this panel? I don't see him here. Then I will look to Ms. Ingram or any other representative of the CHE-FOCA. Do you have questions for this panel?
Just one.
Okay, please go ahead.
We weren't sure if the answer to contacting the landowners to acquire land, did they say they tried to contact all of the landowners or some of the landowners? I missed that. I'm sorry, and so did my cousins.
So I'm sorry, just ask the question. Are you talking about as far as the notifications that we send out for landowner meetings? Is that your question?
Yeah.
Thank you. So yeah, that database is from the county parcel database associated with the county assessor's office. That includes all of the APN numbers within the project footprint as defined by, I believe it's Exhibit 16, which outlines the parcel maps for the reservoir footprint area and for the Dunnigan pipeline. Those are, and it's both Colusa, Glenn, and Yolo County for the Dunnigan pipeline. Those are the note.
I believe we lost Mr. Spessert.
We should know.
So, Mr. Spessert, I'm sorry to say we lost you for a moment. Can you
can you hear me now?
Yes, we can hear you now.
Oh, okay, I'm sorry.
Rewind about 20 seconds. I don't know if that's possible. We may have lost you again.
Can you hear me?
You're now back, but maybe try turning off your camera. We'll see if that helps.
Okay.
All right, go ahead. Please.
How was that? Is that better? Can you hear me
all
right?
now. Right now we can hear you.
Sorry about that. Yeah, so we utilize the assessor parcel data information from Colusa, Glenn, and Yolo counties to send out to all of the landowners within the identified project footprint of the reservoir facilities. And so that's where that mailing list and the invite notification comes from.
Okay, that's maybe I asked that wrong. Did you notify everyone on that mailing list, and did you have meetings with everyone on that list?
Objection, compound.
Well, let's start with, we'll start with the first part, Mr. Spessert, if you could answer just to be clear, did you mail notice to everyone on that mailing list?
Yeah, we did a mailing to everyone on that database, again, based on the parcel data information from the county assessor's office. When we did our landowner meeting back in July, that was the database that was utilized, and that was those addresses were the ones it was mailed to.
And then I'll follow up to ask, did you actually meet with all of the landowners on that list?
We have not met with all 250 landowners. We've met with a portion of that list.
Back to you,
And
Ms.
that's any landowner that's within that footprint, correct?
Correct.
Okay. Well, would it surprise you to know we talked to somebody this morning who said they weren't notified, or would that, maybe I'm assuming, does the footprint include the part of that's not covered by water, but it's right up next to the water? Is that part of the footprint?
Yeah, great question. I think it depends on how far the parcel is away from the footprint. We try to do a little buffer around the reservoir footprint itself. It really depends on how far the landowner that you're talking about is away from that buffer.
Can you tell us how far that is?
You know, I think the way we pull the data is for one parcel beyond the reservoir, the high water line of the reservoir. But I would have to
let me follow up on that, Mr. Spesser, just to make sure I understand. So let's say this is hard to do. We'll imagine in our minds you have a parcel and the high water mark goes through the parcel. So you would notify, that's parcel A. So you would notify parcel A, and then there's a parcel that's adjacent to parcel A, but does not touch the footprint of the reservoir, the high water mark of the reservoir. You would notify both parcel A and parcel B. Is that
is correct. That is correct.
Thank you. Ms. Ingram, back to you. I'm sorry. Thank you for allowing me to interject here.
Okay, I think that answered my question. I'm not sure I understand how we got different information from a landowner, but I'll circle back with that landowner.
And that's something it can be raised if you think there's an issue there, that may be something that has potential to be raised in rebuttal, in which case you would submit testimony or other evidence related to that.
Thank you. That's helpful very much. Appreciate that. Okay, that's it for us. Thanks for this witness.
Thank you. Thank you. And just to clarify, Ms. Moore, you don't have additional questions for these two witnesses, do you?
Nope, she's doing a good job. Thank you.
Thank you very much. I believe now will turn to the Delta users, and I see Ms. Meserve, you are here. Do you have questions for these witnesses?
Good afternoon, Hearing Officer Kinsey. Yes, I just have a couple of clarifying questions, having heard the testimony.
Please, go ahead.
So it won't take long.
Great.
Good afternoon, Mr. Robinette and Mr. Spesser. I think these questions are probably for Mr. Spessert. Is it Spessert or Spesert?
Spessert.
Thank you. I represent the County of San Joaquin, so we're primarily involved in downstream impacts, but I am trying to understand the impacts on the ground up there as well. And earlier, just a couple minutes ago, Mr. Spessert, you mentioned that a portion of the landowner list had responded. Can you clarify what portion, or estimate the portion that did respond?
I would characterize it as we send these regular notifications out to landowners, inviting them to participate in landowner meetings. And on average, we get 35 to 40 landowners. They vary from landowner meeting to landowner meeting on who participates. I would say that out of those meetings, we have follow-on meetings, one-on-one meetings with those landowners talk about specific issues as it relates to their parcels. I think in addition to that, based on the work that we do in the Maxwell area, we get introduced to additional landowners who may not have participated in any of our landowner meetings, but who we schedule meetings one-on-one with to talk about the project, update them, to talk to them specifically about the project's effects to their parcels.
Now, in your testimony on paragraph 6, you mentioned that there's approximately 250 parcels that would need to be acquired. Could you estimate out of the 250 who the Sites Authority, how many the Sites Authority has been in contact with directly?
I would say of the entire list of parcels in there, I would say we have met with well over 120, 130 of those landowners over the breadth of time that the authority has been doing their landowner coordination activities, going all the way back to the when the authority board was formed in 2010.
And the other question I had was on September 19th, on the Terrestrial Biological Resources panel, we heard from Ms. Hale that she was directed by the Sites Authority not to survey for biological resources from public roads out of what she phrased as respect for the community. And I was wondering, Mr. Spessert, given your testimony that the community's been notified of the intent to purchase property, why do you think biologists would not be allowed to survey from public roads?
Objection calls for speculation.
I'll allow Mr. Spessert to answer to the extent you have any firsthand knowledge about this issue. Then I don't know that it's speculative. I guess let me ask the question this way. Well, Ms. Meserve, can you ask the question in a way that has to do with within the scope of Mr. Spessert's knowledge or conversations that he may have had?
Sure, I will try. Are you aware, are you aware, Mr. Spessert, of any direction being given to the biological resources consultants not to survey from public roads?
I don't have any firsthand knowledge of direction being given. I would say that to address your question, I think it has to do with, you know, doing those surveys from the public right of way. In other words, looking over the fence at people's private property who may or may not have provided access to that property. Creates a little bit of I think a challenge for the authority, particularly if a landowner had denied access to that property to do biological studies, and then the authority potentially deploying environmental survey crews into the public right of way to look over the fence, so to speak. Definitely is not in alignment with the authority's view of and value of respect for the local communities, and in that instance, the landowner. I think the other part that I would say is that having our survey team members out in the public right of way could potentially put those team members at risk. Having them standing in the right of way on public roads, looking over the fences could be, you know, just by the nature of them being out there where there's vehicle traffic going on, you know, could be a potential issue. And I think number two, just not wanting to put a landowner out there into a survey crew member out there in a position where they might have a confrontation with a landowner who had denied the authority access to the property. Probably a consideration of why it was deemed not to want to do that work in the public right of way.
So would it be fair to say, Mr. Spessert, that there are landowners that are not interested in selling their land for this project?
I think that's fair.
And do you have any estimate of what percentage of landowners you've interacted with out of the, I guess you said over 130 responded that would be willing sellers?
I couldn't speculate on the number who would be a no. I could say that in the discussions that I've had with landowners, I would say that there are ongoing discussions about what the acquisition phase looks like for the project moving forward. I think it's likely that some landowners will not be supportive of an acquisition, but I couldn't give a number or a percentage or speculate what that ultimate number will be.
And is it possible that there's several landowners that don't even know about the plan to acquire their property?
Objection calls for speculation.
Can you be more
Withdrawn.
specific, Ms. Meserve?
Okay. Well, yeah, I was just getting at, it sounded like the APN lists are not great ways to contact people, so that was my only point.
I would object to the extent that's counsel testifying.
It's stricken for evidentiary purposes.
That's all I have. Thank you very much.
Thank you, Ms. Meserve. Is there anyone who I missed who has additional questions for this panel? So I have a few questions for this panel, not very much. And I think they're just for Mr. Spessard. Mr. Spessard, I'll tell you in advance, I might misstate your testimony, so please correct me. But I believe I heard you say that the authority attempted to reach out early and contact landowners early and start these conversations so that the landowners could, and I believe the phrase you said was consider their options or consider options. And I was wondering whether you could more fully explain what you meant by those options.
I think, as I stated, the authority has had a very proactive landowner coordination program going back to when the authority was founded in 2010. I didn't come on board to the authority until 2017. There was a lot of groundwork that was completed by the authority in those 7 or so years of engaging with landowners. And that was really kind of early on in the project's kind of development. I guess you could say that the project has been, and being a local person, being from Colusa County, this project has been on folks' radar and understanding for many, many decades. And so I think that when the authority was formed up and started having these coordination meetings with landowners, they were starting at kind of a common point because the project had been going on for so long. So there was a lot of work that was put on to get the landowners and the local community, I think, together in understanding what the project was going to look like and working through the design and things like that. When I came on in 2017, the project really kind of started into that process of moving towards final planning and thinking about what construction would look like. And what construction would look like, what acquisition would look like. And so we started early on in 2017 to start reaching out to landowners while we were going through the project planning phase to start getting them to think about what acquisition could look like or what acquisition would look like. Start working with them on discussing the different components of a public acquisition for a public project. We've had lots of landowner meetings over those years to kind of coordinate and give them the project update, but also to continue to update them on how the authority will move forward with acquisition when it gets to that point. And then just really kind of highlighting the different components of acquisition. Like one example would be the tax implications that a landowner would have regarding an acquisition. Again, it's not the authority's it's not appropriate for the authority to give tax advice to a landowner on what happens on a public acquisition, but encouraging them to reach out to their tax professional or their legal counsel so that they fully understand the implications of a public acquisition. Helping to provide those resources and direct folks to that type of information has really been an important part of our coordination activities. And then I think going back to what I talked about as far as soliciting feedback from landowners, particularly for those who will have properties remaining adjacent to the reservoir or to the authority's property, is helping us understand their operations and helping us design the portions of our project that affect their properties in a way that limits the long-term effects to their operations in the future. Has been an important component of those coordination efforts with the landowners.
Thank you. So let me drill down a little bit. I just want to make sure I'm not an eminent domain expert, so I'm trying to wrap my mind around this a little bit about how this works. I can understand options with respect to those parcels that were portions, or portions would remain, or they would be adjacent to the reservoir facilities. Are there options for those landowners whose parcels would be entirely inundated and would be subject either through eminent domain or through a purchase agreement to being purchased in full? Are there options for those? Are there multiple paths?
For those in the inundation area, I don't know. Options is probably not the right word. I think when I talk about options, it's understanding things like the tax ramifications for an acquisition. I think and there are certain I wouldn't say tax benefits, but there are certain things that in the tax code that a landowner can consider as part of a public acquisition process for the proceeds of that acquisition or the proceeds of the sale. I think that's probably more reflective of what I mean by options when we talk about the acquisition of those folks who will be inundated, who won't have any remainder land left.
Understood. Thank you. I appreciate that. And then with respect to the, I guess not just the town of Sites, but I was wondering if you know the number of individual homes that would be inundated within the footprint of the reservoir?
Within the footprint of the reservoir, so in the Sites Valley, the number kind of changes kind of on a fairly regular basis of the folks who actually live inside the Sites Valley. The last number that we took, again, as an estimate, was about 15 people who lived in the valley itself. Several of those living kind of in the town site of Sites. It varies. People move in, people move out. The kind of the Sites Valley has had a declining population over the last year. There's less folks there than there were a year ago. There's very limited housing there. So folks aren't moving in quite frequently.
Thank you. And do you know or have any sense as to the percentage or the number of residents in the Sites Valley who are landowners versus renters or have some other arrangement that are not landowners but live in the valley?
Yeah, I would have to speculate on that. I don't know what that number is. I know of maybe 2 people, maybe 3 who are actual renters within Sites. Most of them are owner occupied.
Thank you. I really appreciate that. And then I think I have now just one question. Well, not one, maybe not one question, one topic for you, probably best for you, Mr. Robinette, with respect, well, I'm not sure, maybe for both of you, about the Dunnigan pipeline. So we went out there and we had a chance to see in general where the Dunnigan pipeline would enter the Calusa Basin drain. And I believe, Mr. Robinette, you discussed the diameter of the pipeline, was that proposed at approximately 10 feet? Is that right?
Yeah, up to 10.5 feet in diameter.
And then 10 feet under, on average, 10 feet below the surface of the ground? Is that also?
I believe it was 6 feet actually.
Okay.
Yeah.
Have you assessed or considered whether the alignment of the Dunnigan pipeline would affect any diversions out of the creek? I forget the name of the creek. You can remind me.
Out of Bird Creek?
Must be Bird Creek. Yes, that's
The
correct.
one that we generally follow
Right.
In parallel. I don't think we've studied that in particular, but I assume based on our kind of policies and the board's values that we would ensure that we do not impact the ability for anybody to divert off and for anybody who has existing diversions to make use of them.
And then did I understand, I believe you spoke to this, but that similar consideration would be made if there's drainage from the fields into Bird Creek. Is that correct?
Yes.
I think those are all the questions that I have. I will look to you, Ms. Chester. Would you like to answer whether you have redirect now, or would you like to take a break first?
Break, please.
Okay, let's go ahead and please we'll take a 10-minute break. We'll come back at 2:58. Thank you. I'll look first to Ms. Cott. Are you ready to go back on the record?
I am, with one question that I get to ask.
Sure.
There was a mention of an Elizabeth Castle, and I don't want to assume how to spell Castle, and I didn't see her on the appearances on Zoom.
Who mentioned Elizabeth Castle?
It was one of the Indian tribes.
Me, it was me, Che Foka.
Thank you.
We can answer that.
She stayed on YouTube because she wasn't going to talk.
Okay, is Castle just CASTLE, or does she spell that a different
Yes,
way?
it is.
Okay,
Yes.
perfect. Thank you. I just wanted to confirm that. With that, I'm ready to go.
Thank you. Thanks to everyone. And with that, I will look to you, Ms. Chester. Do you have redirect questions for the witnesses?
Yes, briefly. Mr. Robinette, do you recall a question on cross-examination regarding exhibits in the record containing the cooperative agreements described in paragraph 22 of your testimony?
I do.
And do you now recall the 2 sites exhibit numbers for those agreements?
Yes, Sites 218 is the cooperative agreement between TCCA, GCID, and the authority, and Sites 220 is between RD 108 and the authority.
Thank you, that's all.
Thank you. With that, I will look to the room. I don't think there should be, but are there any follow-up questions based on that redirect? And with that, I will look, looks like we're looking to you, Mr. Ferguson. Are you prepared to put on, I believe it's panel 8?
We are. We are.
So, great. And if you would please identify the witnesses and we will get them pinned.
Yeah, Mr. Matsui and Dr. Jaglo.
I believe they both have to turn on, if Mr. Matsui and Dr. Jaglo, if you would please turn on your cameras, we can bring you up here.
Right.
There we go. And I will start by administering the oath. If you would please, Mr. Matsui and Dr. Jaglo, go off mute and then raise your right hand. Do you swear or affirm under the penalty of perjury that the testimony you will give in this hearing will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you. Please go ahead, Mr. Ferguson.
Thank you. The purpose of the authority's final panel is to present evidence on hearing issue 3D, which concerns whether the proposed appropriation of water is in the public interest, and specifically this panel concerns the authority's greenhouse gas emissions analysis. And you'll hear from 2 witnesses. First, Mr. Corey Matsui will provide testimony regarding the authority's greenhouse gas or GHG analysis and proposed mitigation. I'm sorry, adopted mitigation. And then you will also hear from Dr. Kirsten Jaglo regarding the authority's analysis of GHG emissions resulting from land use and land use changes related to the construction of the project. So we're going to begin with Mr. Matsui. Can you please state your name for the record?
Corey Matsui.
And is Exhibit Sites 27 an accurate statement of your written testimony?
It is.
And did you prepare that written testimony?
Yes, I did.
And is Exhibit Sites 269 an accurate summary presentation of your testimony?
It is.
And did you prepare that summary presentation?
I did.
Does Exhibit Sites 28 contain an accurate statement of your qualifications?
It does.
And do Exhibit Sites 29 through 38, which were submitted with your testimony and cited therein, include true and correct copies of documentation concerning GHG modeling and mitigation?
Yes.
Great. Would you please go ahead and summarize your written testimony using Sites 269?
Mm-hmm. Yeah, if we could just bring that up. Thank you, Ms. Mullen.
Good afternoon, Hearing Officer Kinsey and members of the board. My name is Corey Matsui. I'm a senior greenhouse gas specialist with ICF. And today I'll be summarizing my testimony on the greenhouse gas emissions analysis for the SITES project. Next slide. So this slide shows an outline of my testimony, which will cover three main topics. The first of which is an assessment of the GHG emissions analysis in the final EIS. The second is an assessment of an alternative modeling tool called AllRes. And the third is with respect to the project's mitigation and net zero emissions commitment. Next slide. With respect to my qualifications, I've been employed with ICF as a greenhouse gas specialist for more than 13 years, and I've worked on the SITES project since 2020. I was the lead greenhouse gas emissions modeling analyst for the project and the lead author of Chapter 21, Greenhouse Gas Emissions, of the draft and final environmental documents. I was also the lead preparer of responses to comments for Chapter 21 of the final EIS. And my summary testimony today is primarily based on the FEIR EIS. Next slide. So overall, my testimony supports the opinions that the FEIR EIS provides a reasonable estimation of greenhouse gas emissions from the project, and that the project's mitigation in the FEIR EIS provides a feasible plan for achieving net zero greenhouse gas emissions. Next slide. So with respect to the assessment of GHG emissions analysis in the final environmental document, my opinion is that the analysis of GHG emissions is comprehensive and accurate. The methods are thoroughly described in the methodology section, and the analysis is based on publicly available modeling software and methods recommended by expert agencies. The analysis includes reasonably foreseeable sources of GHG emissions, and the estimated construction emissions are about 350,000 metric tons of carbon dioxide equivalent in total, plus or minus 1 to 2,000, depending on the alternative. The operational emissions range from about 57,000 to almost 73,000 metric tons of CO2e per year. For the final EIS, an analysis of emissions from land use change was added to the document, and the methods for that analysis were based on Intergovernmental Panel on Climate Change guidance. IPCC is recognized as a global authority on greenhouse gas methods, and 190 experts were involved in the 2019 methods guidance that was used for the analysis. The numbers on this slide reflect the addition of the land use change analysis that was added to the final draft of the document. Next slide. Next, I'll discuss my assessment of an alternative modeling tool called AllRes from Save the World's Rivers and other groups. Certain protestants have put forth an alternative estimation of the project's emissions based on the AllRes modeling tool. AllRes is an alternative modeling tool, and it's a proprietary model, and it is acknowledged to be under development on the model webpage. The model is not available for download by the public, and there's no methodology documentation. By methodology documentation, I mean that there's no user guide or a methods document that clearly shows the formulas or calculations that were used to model emissions. Additionally, the model has no known endorsement from IPCC, US EPA, the California Air Resources Board, or air quality management districts in the project area. The total emissions, as stated in the AllRes report prepared for the SITES project, are 362,000 metric tons of CO2e per year. And there's an uncertainty range associated with that value, which ranges from about 100,000 to more than 800,000 metric tons per year. And I have a figure to show that when I get to the next slide. To ensure accuracy and replicability, in my opinion, methods used for environmental analyses should be extensively reviewed and validated by independent experts. In my opinion, AllRes does not meet these criteria. Although methods may continue to evolve in the future, experimental methods that have not gone through validation and testing should be used with caution, in my opinion. Next slide. This slide shows figure 4 from the All-Res report that was prepared for the sites project. And it shows emissions by source. The bar on the far right shows the total emissions from the project, which are again 362,000 metric tons of CO2e per year. The thin black line in between the bar shows the uncertainty range, which again extends for a quantity of more than 700,000 metric tons, which is nearly double what the total stated emissions are. So not only has the model not been subjected to widespread scientific review, but it also has a considerable amount of uncertainty. And in my opinion, these factors preclude any meaningful application of the model or the All-Res report prepared for sites for policy or decision-making purposes. Next slide, please. Lastly, I'll discuss the project's mitigation and the net zero emissions commitment. The authority has committed to meeting a net zero emissions standard via mitigation measure GHG 1.1 from the final EIR EIS. And what this means is that the emissions presented in the document must be reduced to zero. The net zero standard is consistent with the state's GHG goals, specifically Assembly Bill 1279, which is the California Climate Crisis Act. And that bill requires that the state achieve carbon neutrality by 2045. I wanted to note that the project will be operational before 2045 and will achieve net zero emissions while operational via the mitigation measure. Thus, the project will achieve a goal consistent with AB 1279, but on an accelerated timeline. In my opinion, the mitigation measure is strong and defensible because there are monitoring and reporting requirements that are clearly defined. There's a requirement for the authority to document compliance with the net zero emission standard on an annual basis and show any corrective action that may be needed to ensure that the standard is met. The priority, as defined in the measure, is to reduce emissions at the site or nearby communities first, and then GHG offsets will be used to mitigate whatever emissions are remaining. I wanted to note that GHG offsets are accepted by CARB for the cap and trade program, and the CEQA guidelines also allow the use of offsets for mitigation. The mitigation measure includes strict definitions for how and what offsets can be used to ensure that reductions are actually achieved. Next slide, please. In conclusion, the final EIR EIS for the sites project provides an accurate and reasonably comprehensive estimate of the project's emissions. All-Res is an alternative modeling tool, but it is not available to be used by the public and has not been subjected to widespread scientific review, and it is also under development still. It also has considerable uncertainty as applied to the sites reservoir project. Thus, it does not provide meaningful results for decision makers, in my opinion. Finally, the project's GHG emissions will be mitigated by the authority's commitment to the net zero standard and will thus not contribute significantly to climate change. Thank you, and that concludes my summary.
Thank you, Mr. Matsui. Dr. Jaglow?
Hello, and good afternoon. Can you hear me? I was having trouble with my computer.
We can hear you, but it's a little muffled. So if you just maybe stay close to the microphone.
Try. How's this? Is this better?
That's much better.
Okay, all right. Sorry, my technology never works when it's important.
Dr. Jaglow, will you please state your name for the record?
Yeah, my name is Dr. Kirsten Jaglow.
And is Exhibit Sites 117 an accurate statement of your written testimony?
Yes.
And did you prepare that written testimony?
Yes.
And does Exhibit Sites 230 contain an accurate statement of your qualifications?
Yes.
All right, would you please summarize your written testimony contained in Sites 117?
Yes. So, in terms of my qualifications, I am the Senior Agricultural Advisor at ICF, where I have been employed for over 14 years. I have a PhD in Crop and Soil Science, Plant Breeding and Genetics from Michigan State University. And I have a BA in biology with a minor in chemistry from the University of Minnesota Morris. My work at ICF has focused on the greenhouse gas or GHG impacts of land use change in forestry, from clients ranging from individual companies to states and to the US federal government. Just a few examples are I've been involved with NEPA assessments for DOE and USDA, and I provided expert guidance on GHG emissions and removals associated with proposed compensatory mitigation for the California Delta Conveyance Project. I provided guidance on the greenhouse gas emissions related to the site's reservoir project to Corey and the ICF team. In terms of my expert opinion, I did not participate in modeling the greenhouse gas emissions, but I am very familiar with the IPCC approaches that were used, and I reviewed the work that was conducted by AECOM, the contractor that worked with us. As Aaron said, my focus was on the biological-based emissions, such as those from land use change and ongoing emissions from the reservoir once constructed in the future. I found in my analysis that the greenhouse gas emissions were both NEPA and CEQA compliant by including emission sources that are reasonably foreseeable, and they are consistent with current IPCC guidance. I am of the opinion that the greenhouse gas analysis for the EIS provides a reasonable estimation of greenhouse gas emissions that may occur resulting from the land use and land use changes related to construction of the site's reservoir. And that
Thank you, Dr. Jaglow. We're done with direct examination and ready for cross-examination.
Thank you. I will look to the coordinating NGO parties. Which of you would like to go first? I see Ms. Tinney.
Yes, thank you so much. My name is Frances Tinney, and I'm an attorney with the Center for Biological Diversity. I'll be starting the cross-examination. Can you hear me okay?
It's a little muffled. I don't know if we can have a similar turnaround as Dr. Jaglow, but
I hope so. I agree with Dr. Jaglow about how difficult it can be. If I talk louder?
I think, yes, that would be fine. We can hear you fine.
Okay, thank you so much. Let me know if you ever can't hear me. So thank you both so much for being here today. Start with, I'd like to ask Ms. Mullen to pull up exhibit FOR 170. If we could start with,
just take a moment.
Yeah. Great, thank you. Are either Dr. Matsui or either Mr. Matsui or Dr. Jaglow familiar with this document?
I am, yes.
Great, thank you so much. Did you have any role in preparing it?
I did, yes.
Okay, thank you. Could we go to the table at the top of page 2? Great, thank you. Thank you so much for zooming in on that one. So I assume you recognize this table and you're familiar with it?
Correct.
So I want to start with line 3. Are you familiar with facility decommissioning as a potential source of emissions?
Am I familiar that it could be in certain situations a source of emissions? Is that what you're?
Yeah, yes.
I understand that there's literature out there that have looked into it.
Do you have an understanding of what emissions those would be, how facility decommissioning would create emissions?
I would say at a high level, yes. I'll say for this project, the decommissioning would be outside of the scope of the project, so it was not necessary to take a closer look at that source of emissions.
Okay. Would it be correct to say that it includes construction emissions from removal of the dam and infrastructure at the end of its life, as well as methane from decomposition of lakebed sediment? Would you say that's roughly your understanding?
Objection compound.
Break it apart, Ms. Tinney, please.
So one of the things that might be included in that would be essentially deconstruction emissions from removing the dam and the infrastructure at the end of its useful life. Would that be one component?
I would say generally yes, for this specific project that doesn't, it's not really being constructed to have a specific end date. In 100 years from now, that's just too speculative to I would say even consider, what kind of activities would be involved. I would wager a guess that at that point everything will be all electric, and there would not be any emissions from equipment.
You expect the reservoir to be functional for 100 years or more?
I'm not really sure, to be honest, what the anticipated lifetime of the reservoir is. However, I would imagine that it would operate for some time in the future.
Okay, and then another component of what we might call facility decommissioning emissions might be methane that would be released when sediment that builds up on the lake bed is released back into a river. Would that be correct?
Again, I would say that would be too speculative. I mean, that might happen in some cases currently, but many decades from now, I couldn't say what would happen. And perhaps the reservoir would be simply stabilized as is, and there would be no major sediment movement. It's too speculative at this point.
Okay, I appreciate that. Are you familiar with cradle to grave life cycle analysis for greenhouse gas emissions?
Yeah, generally I am.
Would it be true that emitting emissions from the end of the project's useful life means that this is not a cradle to grave life cycle analysis?
I would say
vague as to this.
Okay, does emitting the emissions from the end of the project's useful life mean that the GHG analysis contained in the EIR is not a cradle to grave life cycle analysis?
I would say that's accurate, but the analysis is consistent with the California Natural Resources Agency in that they have expressly declined to include requirements for life cycle analysis in the CEQA guidelines. So I would say the analysis is sort of standard CEQA practice.
Thank you. Moving to the fifth line of the table, are you familiar with decay of organic matter on exposed banks as a potential source of emissions?
I would say I'm not thoroughly familiar. Dr. Jaglu might have more expertise, but that's not something that I have a robust background in.
Okay. Dr. Jaglu, would you agree? Would you like to handle questions on this line of the table?
Sure.
Thank you. What's your understanding of what decay of organic matter on exposed banks means?
Just my understanding in general.
Yeah, yes.
So organic matter, which would be, probably mostly plant matter, right? As living organisms assimilate carbon, which is required to make methane, and then as organic matter decomposes, it can release methane and CO2 and other gases.
Thank you.
That would.
Yeah, thanks. Is it possible that this would happen as part of operations of the site's reservoir?
Objection vague. Which,
Is it
where?
possible that organic matter would decay in the way that you're describing and create emissions during operations of the site's reservoir?
Objection vague as to location and timing.
Right? You can at least, let's add location. I think you said during operation of the site's reservoir, so we'll leave it at that. But where are you referring to, Ms. Tinney?
I'm referring to organic matter on the exposed banks of the reservoir as water levels fluctuate in the reservoir.
I believe that's to you, Dr. Jagla.
Okay, sorry. Do I believe that could happen? Yes, just in terms of how biology works, yeah, if water levels go up and down and there's plant organic matter there, yes.
Thank you. And you would agree that those emissions from that process that you're describing were not included in the GHG analysis in the EIR, is that correct?
So the analysis was conducted using guidance from the IPCC, specifically the 2019 revised guidance, which includes guidance for reservoir. And if you read through that guidance, this particular source is not listed. And so we went along with IPCC guidance.
Thank you. It's not listed either way. The IPCC guidance just doesn't mention this. Is that, am I correctly understanding what you're saying?
So the guidance at a high level basically walks you through, in this case, you need to look at these emissions and these emission sources. And so we went through or I didn't, but AECOM went through and conducted emissions analysis for all of those sources.
Okay, thank you. And decay of organic matter on exposed banks isn't listed as one of those sources?
Not for reservoirs, no.
Now I'd like to move to the 7th line of the table. This lists an emission source. This lists emissions that might come from land use changes away from the reservoir, which is then defined in parentheses as carbon leakage. Are you or Dr. Natsui familiar with that potential source of emissions?
I can go first. The framing of this source, the text is from the ALRES report for sites that I had mentioned in my testimony. I don't recall the exhibit number offhand, but my understanding of what this specific text means was informed by the report that also used this specific text.
Thank you. Could you tell us what that understanding is?
Yeah,
I
might not be able to capture it all, but I believe that one component was sort of replacement of the land that's been displaced by the reservoir, so settlements or grassland. I believe the model assumed that, or the model users assumed that they included emissions from replacing the displaced land. And that was kind of the main component that I'm recalling.
Thank you. Is it possible that land uses that are currently going on within the reservoir footprint might be displaced out and continue to take place somewhere else once the reservoir is created?
Objection calls for speculation.
I'm going to overrule it and allow it. Mr. Mitsui.
Yeah, I would say that's possible. And again, I would say that's outside of the scope of the project, because when those uses are replaced, that would be a new and separate action that would go through environmental review. And it kind of begs the question, well, those uses would also be displacing land, et cetera, et cetera. So you would have to draw the line somewhere, and I think what we've done is appropriate.
I appreciate that. I understand that. Just to clarify, it would have to go through environmental review if it was an action that required a governmental permit, but there might be some land uses that wouldn't require that kind of permit and wouldn't go through environmental reviews. Is that right?
Objection calls for a legal conclusion.
Okay.
That's fair. Go ahead, move to your next question, Ms. Tinney.
Yeah, thank you. Okay, I think we can move down to the 8th line of the table. The emission source, land use changes beneath the reservoir. What's your understanding of what emissions stemming from land use changes beneath the reservoir might?
Well, I can go ahead, and then I might pass it to Dr. Jaglow. But again, this specific text was from the report from the protestants. So my understanding was informed by, the compilation of sources that they've put in this, within this category. And the footnote below summarizes what I think is, included within that source category.
Great, thank you. So the things that are listed there that the chart is indicating were not included were loss of sequestration. Oh,
sorry, I thought that was a question. I was just going to say that's correct.
okay. Would you like to read that footnote and just tell us what is not included?
Yeah, I can just read footnote 2 if that's what you're asking.
That would be great, thank you.
Does not include loss of sequestration, ecosystem carbon loss from dewatering of wetlands, riparian areas or mangroves, or emission releases from decaying, riparian vegetation due to fluctuating river levels.
Thank you. And you would agree that those categories of emissions were not included in the EIR's calculation of greenhouse gas emissions, is that right?
Yeah, that's right. Consistent with IPCC guidance.
Thank you. And again, just to clarify, IPCC doesn't tell us not to include those. Those just aren't listed in the equation. They aren't listed as among the sources that must be included. Is that right?
Well, yeah, that's right. They couldn't possibly say everything not to include.
Thank you. All right. Okay. I appreciate that. We're done with that chart now. I'd like to move on to some questions about chapter 21 in the FEIR, the GHG section. I don't know if we need to look at it, but maybe that is helpful. It's the specific section that I'm going to be discussing is on page 7 of chapter 21 of the GHG emissions, which I think is in various places in the record, but the site I have in front of me is AHO 88. Thank you so much. And then the bottom of page 7, I think is where I want to start. Perfect, thank you. So my question about this section of the EIR, is it it's telling us that emissions factors for electricity decrease in magnitude for each future year. And the emission factors were scaled based on the state's goal of carbon-free energy by 2045. Is that telling us that the GHG analysis is assuming that all the electricity the project uses after 2045 will contribute zero GHG emissions?
Yes, that's correct, consistent with state law.
Thank you. Do you have any sources establishing that the state is likely to meet its goal of a carbon-free energy system by 2045?
Well, it's so it's required, it's state law now to meet these targets. Are you asking for something additional?
I'm asking if there's a possibility, if you're aware of a possibility that that might not happen, even if the state has stated that as a policy goal.
I have never seen any indication that would lead me to believe that the goal would not be met. My understanding is that, just looking at my notes, that the latest data shows that 61% clean energy in 2022. And if I'm remembering correctly, I believe the goal of 60% is for 2030. So, they're quite ahead of schedule at this point.
Thank you. If the state doesn't hit the target and the energy system is still producing some carbon in 2045, how would that affect the actual GHG emissions versus what is estimated here?
If that were to be the case, then the emissions could be higher, but that would show up as specified in the mitigation measure, which requires that the authority can recalculate emissions, ongoing operational emissions, to determine what their reduction commitment would be. So if the energy emissions were higher than expected, then they would be responsible for mitigating those emissions.
Thank you. So effectively, if the project isn't using carbon-free electricity in 2045, then the authority would purchase more offsets to mitigate for that excess emissions. Is that right?
Almost. So the mitigation measure specifies that the emissions can be reduced through on-site measures, off-site measures, or offsets. So there's just a bit of nuance there.
Yeah, thank you. I appreciate that. Speaking of nuance and how the first step is reducing on-site, is it possible that the authority could choose to purchase fully zero carbon electricity, even if the state grid was not entirely carbon free?
Objection calls for speculation.
To the extent you can answer, I'll allow the question, Mr. Mitsui.
Yes, they could. A bit of speculating here, but they could, increase the quantity of renewables that constitutes the energy used for the project.
Thank you. Just to make this less speculative, could we maybe go to page 20 of this document? I think there's some more information about this. Could we scroll down? I think this, in off down a little bit further, we're looking at B1. I'm sorry, it's the next page, where it says offsite measures and then 1. And one more page, I'm sorry. Okay, here. Thank you so much. The first sentence in 1, the authority will increase the proportion of renewable energy purchases for the project's electricity needs to the highest amount that is feasible. Are you familiar with that commitment?
I'm sorry, I'm not quite seeing. So do you mean I?
Sorry, yes, B, and then the first sentence in I.
Yeah, I'm familiar with that text.
In this context, how would feasible be defined?
That's sort of a decision that would extend beyond my expertise and area of consideration. It likely has costs implications and things along those lines. So I'm not really able to speculate about what the various factors could be that the authority might consider.
Thank you. Do you know who would make that decision, or what group would make that decision?
I don't know offhand.
Okay, fair enough. Thank you. Thank you so much. Then I think done discussing this document. And now what I'd like to do is go to AHO 223, which is Appendix 21A, the GHG support appendix. Thank you so much for all your help with these documents. Could we go to page 9? Thank you so much. So this is the equation I'd like to look at. Methane emissions from lands converted to flooded lands. And before I get started with this, I'd like to ask, I sent in an exhibit just for use during this cross-examination this morning. I don't know if that was received and available to be used. I don't want to get to it yet. I want to ask just so I know.
I believe so, but I will check in with the team. Did you label it in a particular way? How was it labeled?
I labeled it FOR 251.
Great. So I will ask the team to confirm that we have FOR 251. I'll let you know if we.
Great. Thank you so much. I appreciate that. So to get started, I'm assuming Dr. Jaglow might be the one who's more familiar with this equation, but I'm not sure. Either expert who'd like to take these questions, I'd appreciate it. But are either of you familiar with this equation, or?
I am, yes.
Yeah. Great, thank you so much. Could you tell me what factor A alpha in this equation represents? I'm sorry, I'd like to start one step back. Could you tell me what this equation is? Did you use this equation when you were conducting the GHG analysis?
Objection compound and vague. I'm not sure. I see a lot of equations.
We're looking at equation 5. I'm looking at equation 5 for calculating CH4 emissions from lands converted to flooded lands. So when you were calculating methane emissions based on land use change in the EIR, did you use this equation at the top of the page here?
Yeah, our modeling team did use these equations.
Thank you. And what does factor A or alpha in this equation represent?
I think I might pass that one to Dr. Jaglow, who could probably do a much better much better justice to that than I could.
So alpha is it's an adjustment factor because a lot of things in biology, temperature has a huge impact. And so alpha is it's at a factor, so you can adjust the climate zone, which can make the formula more accurate for a given area.
Thank you. So when it says in the document, it's an adjustment for the trophic state, what's your understanding of what the trophic state of a reservoir refers to?
I don't know how I would describe that. I'm sorry, I can't.
Okay, would you say it's correlated with the level of nutrient load in the water?
Yeah, I mean, it's sort of like the amount of biomass. So I don't know if I would say nutrient load, but the amount of biomass in water at a given time and place.
Thank you. And how does the amount of biomass in a reservoir affect the level of GHG emissions from that reservoir?
Like generally speaking, I mean,
yes.
So the more sort of bioorganisms you have, all living things, well, most of these are going to be plants, right? So they're going to be taking in sun and doing photosynthesis, and then they're going to emit waste or expel, like in this case, methane. So the more you have, I mean, it's not a perfect correlation, but the more you have, the more you're going to emit.
Thank you. What in your experience affects how much biomass is in a body of water?
I mean, how much sun there is and temperature. I mean, and nutrients available.
And by nutrients, could agricultural runoff contribute nutrients to a body of water?
Generally speaking, yeah.
Thank you. This might be a good time if we do have that FOR 251.
We do, yes.
Okay, great. That would be great if we could look at that. So yeah, maybe we can pause on the first page to identify this document. Thank you so much. Is it correct to say that this is the 2019 refinement to the 2006 IPCC guidelines for national greenhouse gas inventories, the chapter on wetlands?
I mean, I can't see the whole thing, but it certainly looks like it from this page.
Thank you. I appreciate that. Are you familiar with this document, with the 2019 refinement?
Yes.
Thank you so much. And what I think we're interested in here is on page 15, table 711. So it's the last table. Yeah, right there. Okay. Thank you. Would you agree that this table is giving us potential values of alpha that could be used in the equation 5 methane emissions from lands converted to flooded lands?
I would have to look at it more thoroughly to be able to answer that.
Okay. Okay, I appreciate that. Maybe we could just talk about what is here in this chart. Sorry, I'm thinking about how to approach this. What value did you use for A when you calculated methane emissions from lands converted to flooded lands using equation 5?
Corey, do you have that one? I don't remember off the top of my head.
I am scrolling through to try to find that specific value, but I need a moment.
I'm just trying to see if I have this. I know that it's 1, or I mean, I think it's 1. I'm trying to find my citation for where it says that.
I believe it's on page 21A-9. It does look like default value of 1 is used for alpha.
Thank you so much. That's very helpful. And in this table, can you tell me what a alpha value of 1 would represent, what trophic class that would represent?
I said I'm not as familiar with this table, but it appears like it would be somewhere between oligotrophic and mesotrophic.
Thank you. What's your understanding of what the characteristics might be of a mesotrophic body of water?
I mean, it has to do with the nutrient components and how productive the lakes are in terms of how much biological activity there is.
Thank you. So mesotrophic would be what level of biological activity?
Meso, meaning medium, is like intermediate.
Thank you. And the trophic coefficient, the alpha value that is used in the EIR is 1, which is towards the bottom of the mesotrophic range. Would that be correct?
Yes.
And we can go back. I don't know if we need to go back to looking at the equation for this question. It's just one question, but because alpha functions as a multiplier of that equation, if you had used, if the alpha value was even a little bit higher, if it was 2 instead of 1, that would mean the predicted methane emissions would double. Is that correct?
Assumes facts, not evidence with respect to calling alpha a multiplier.
Okay, then let's go back to the equation we're talking about. I apologize, Ms. Mullen, for all of this back and forth. But again, that's page 9 of AHO 223. Thank you so much. So based on looking at these equations here, would you say it's true that if alpha went from 1 to 2, the outcome of this equation would double?
For the, not for the downstream effects, but yeah, for the reservoir emissions.
Reservoir. Yeah. I could completely be wrong here, but is alpha not a multiplier when we're looking at downstream effects?
No, you're right. Sorry, I was looking at trying to do the parentheses in my head. Yes.
No.
It's adjustment.
Thank you so much. So if alpha went from 1 to 2, the result from this equation would be double. Thank you. That's all I wanted to establish based on that equation.
Well, I'm going to move to strike. I think she acknowledged it's a multiplier, but Ms. Tenney provided the testimony that it would double. So if she wants to ask the question, that's fine. But
okay, I'll ask that question. If alpha went from 1 to 2, would the result of this equation double?
I mean, again, it's in the total equation, right, is in parts, and I can't really do the math in my head right now, but the multiplier would double, yes, for each part individually.
Thank you. Thank you so much. Could we go back to the chart we were looking at earlier in FOR 251, table 711, which is page 15, bottom of the page.
Ms. Tenney, if I can interject too, it just may help with clarity in the record. I'm not sure we identified the table number last time we were talking about this table. It may be helpful, as I think there's another table on this page, right?
Yes,
Okay.
Table 711.
Sorry.
No, I appreciate that. Thank you. Yes, table 711, which is regarding the relationships between the trophic index and the trophic state adjustment factor. Thank you. So just to return to where we were, the GHG analysis in the EIR uses an alpha value of 1, which is the low end of the mesotrophic range here. Is that right?
Yes.
And if the equation had used 2, which would still be mesotrophic, maybe I'll stop there. If the equation had been calculated using an alpha value of 2, that would still indicate a mesotrophic reservoir. Is that right?
According to this table, yes.
Thank you. What level of algae would you expect to see in a mesotrophic body of water?
Honestly, I believe this table is for when you have the body of water and you can actually measure things. I don't know what would happen in the reservoir. I mean, it hasn't been built, and it'd be highly speculative. So I can't answer that question.
I absolutely understand. Just setting aside this reservoir or any particular reservoir, in a mesotrophic body of water, would you expect there to be a lot of algae?
Objection assumes facts not in evidence with respect to any algae.
I don't think we're talking about, my understanding is we're not talking about a specific reservoir. So if, I think it's a fair question if Dr. Jaglow can answer, or maybe it depends, or I don't know. So Dr. Jaglow.
Yeah, I mean, it's one of those things like it's, intermediate productivity. I don't know how many algae per square meter or cubic meter that would be. I don't have a number for that.
Right. I understand that. Could you which of these trophic classes would you associate with a high level of algae?
I'm going to object as this assumes facts, not evidence. Nothing's been established that there would be any algae in any reservoir. And Ms. Tinney's asking questions, assuming there would be algae in these reservoirs, and that this table takes it into account in some fashion.
I'm going to allow the question. I'm not sure it's related necessarily to this table, although I'm not sure where we're going, because if we want to relate it back to Sites Reservoir, then we're at this point. But I'll allow this question, Ms. Tinney, and we'll see where we go.
Thank you. I appreciate
Go
it.
ahead, Dr. Jaglow.
So the point of this table, right, is that you're going from a hypothetical lake where it's very low productivity in terms of plants to a plate where like hypereutrophic is where it's extremely high productivity. I can't give you like a number of organisms or anything like that.
Okay, thank you. We'll be done with the algae. Could I ask about nutrient levels, nitrogen specifically, which is in the table here? Which of these trophic classes would you associate with a high level of nitrogen?
I mean, again, all of these things, you see the TN, which is the nitrogen, that look down the TN, that's how many micrograms per liter there are. So as you go from oligo to hypereutrophic, you have increased levels of nitrogen.
Thank you. Thank you so much. Okay, we can be finished with this chart. Now I'd like to go to AHO 73, which is the surface water quality section of the EIR. Thank you so much. Are either of our experts familiar with the water quality section of the FEIR?
I am not.
I know it exists, but I haven't read it.
Okay. Did you review any information related to projected surface water quality in the reservoir before or while you were conducting the GHG analysis?
The specific modeling team that prepared the analysis in 21A, they were not available to be at this hearing. So unfortunately, Dr. Jaglow and I aren't able to answer that question.
Okay, okay, thank you. I appreciate that. Could we go to the section that is on page 662? I apologize, that's page 62. That's just how the numbering is. Page 62, the bottom, the section titled HABs and invasive aquatic vegetation. So the first sentence of this section says, during initial filings of the site's reservoir, nutrient levels would nutrient, nitrogen, and phosphorus levels would be expected to be relatively high due to flooding of soils and the inundation footprint. Is that true? Is that a correct reading of what that says?
Was that for me?
It's for, yes, it's for you. Thank you.
Sorry, could you repeat that?
Yes, during initial filling of site's reservoir, nutrient, nitrogen, and phosphorus levels would be expected to be relatively high due to flooding of soils and the inundation footprint. Is that a correct reading of that sentence?
Yeah, it sounds like you read it as it's shown.
Thank you. And then could we go to page 80? The last full paragraph. The first sentence of that paragraph, I'm going to read that sentence. In Site's reservoir, similar to other Central Valley reservoirs, nutrient concentrations would likely be sufficient for HAB's harmful algae bloom formation and sustainment in the long term, given that nitrogen and phosphorus would be available in water diverted to the reservoir from the Sacramento River and in watershed runoff. Is that a correct reading of that sentence?
Yes.
Thank you. Based on those two sentences, would you say it's true that the team that prepared the water quality section of the EIR was anticipating that the site's reservoir would have high levels of high nutrient concentrations?
Well, I believe there was a key word in there, relatively high, but I can't tell you what that means relative to what.
Okay, thank you. This might be a question for Dr. Jaglow, but based on that description of the reservoir, which doesn't exist, that's the prediction, but based on that prediction that the water quality team made, what trophic class would you assign to a water body with those characteristics?
Objection vague. Which characteristics?
With the nutrient concentrations predicted here.
Again, you'd have to actually measure the levels to know. I don't know. I understand it would be higher than areas that don't have nutrient runoff from agriculture probably, but I don't know what the actual levels would be because there's so many factors involved.
Thank you. In your opinion, if these predictions in the water quality section of the EIR are correct, is it possible that the site's reservoir would end up having a higher trophic level than 1?
I'm going to object as to Ms. State's testimony. These are not characterized as predictions.
I have to go off mute. I think this is fair. I mean, I understand where you're going, Ms. Tinney. I think we can accelerate this.
Thanks. Okay, I appreciate that.
Yeah.
So you've brought up a couple times that we don't have the information yet. We have to measure these things and we can't do that until the reservoir exists. Is that right?
So like basically the greenhouse gas estimates are all projections, right? The best projections we can make based on current knowledge of a future event that has not yet occurred. So yes, I mean, everything right now is a projection. So there's uncertainty associated with it. So we use the best available methods to make that projection, but correct. in the future with data, you could potentially make better estimates.
Thank you. That's where I was going. Once the reservoir does exist, if operational water quality emissions turn out to be different than the assumptions that were made in the GHG section of the EIR, is there a plan to update the modeling based on actual conditions?
Well, mitigation measure GHG 1.1 provides the authority with an opportunity to reevaluate what the emissions are using, real time or more accurate or more current data, I should say.
Thank you. So if the reservoir exists and the trophic level is, say it's 3, and we can measure it, there is a procedure in place to account for the fact that the emissions from the reservoir surface would triple in that case?
I would say that there's an opportunity for the authority to reevaluate what the emissions are. However, they could also use the emissions as established in the EIS document.
So it's possible that even once we have information establishing that the reservoir is in a higher,
Ms. Tinney, I'm sorry, you're fading.
Yeah, I can't hear.
Yeah.
Oh, I'm sorry. Thank you so much. Okay, thanks. So it's my understanding of what you said is that the authority might reevaluate emissions, but in a situation where the trophic level is much higher, or where the trophic level is higher and emissions are proportionately higher, it's also possible that the authority would not reevaluate in that case.
That seemed like kind of a compound question. Like they're not going to, whether they reevaluate or not, probably doesn't depend on the trophic status.
So the existence of information establishing that the trophic status is higher and emissions are higher by a multiplier would not require the authority to reevaluate their calculations.
I think that's correct. What has been done in the final EIR EIS is consistent with IPCC guidance and also with a public comment that was received from US EPA on the draft document. And that comment indicated that the kind of high level approach that we use for when site specific info isn't available, that's a sufficient approach to use.
That's a sufficient approach to use even when site specific information becomes available?
I can't comment on whether site specific information is available or not with respect to trophic status.
Right, I'm talking about in the future when it becomes available.
Well, the mitigation measure, again, it provides an opportunity for the authority to reevaluate. However, it doesn't, the estimates established in the environmental document are sufficient for identifying what the commitment is, if that's what the authority elects to do.
So the commitment is to mitigating the amount of emissions that were estimated here, and there isn't a commitment to evaluating emissions that would become apparent with future information.
I'm just rereading the mitigation measure text. Just to confirm my understanding. it's like a 9-page mitigation measure, so I don't exactly have all text memorized. Actually, the text says updated emissions analysis conducted for the GHG reduction plan will be performed using approved
I'm
emissions.
sorry, can you read that slower, please? Thank you.
Oh, sure. Updated emissions analysis conducted for the GHG reduction plan will be performed using approved emissions models and methods available at the time of that analysis.
Thank you. So your understanding is that that sentence you just read would require the site's authority to redo the methane calculation based on the observed trophic level of the reservoir once it exists?
I don't think Dr. Jagalo can probably add on to this, but the measurement of the trophic status might not be available for some time, and the authority would need to commit to reducing emissions, in an earlier stage of operation. So I'm not sure that would always be the case.
My understanding is, I'll say that like a question, but when information about the trophic level was available, is it your understanding that the authority would be required to recalculate the emissions based on that when it is available?
I'm sorry, could you restate that? I couldn't really hear you.
I'm so sorry. I'm gonna try to do better at that. So it's your understanding that when that information is available, allowing for the fact that it might be available later, that when it's available, would the authority be required to recalculate the methane emissions based on that information?
I believe so at this time.
Thank you. Is that memorialized anywhere more clearly than it is in the text of the EIR that you've read to us?
I'm not aware of any other description of the mitigation measure that would go into more detail than what is in chapter 21.
Okay, thank you so much. So we can move on from this water quality section. My next set of questions and my last set of questions is regarding offsets and mitigation. So that's in the GHG chapter of the FEIR. I don't know if it's valuable to look at, but maybe we can see how it goes. So I'll start with, according to the EIR, the estimated increase in GHG emissions would be at least 60,000 would be around 60,000 metric tons in average water years and about 70,000 metric tons in dry or critically dry years. Is that right?
I believe so. It might be helpful if we had the table that you're referring to for everyone to look at.
Let's pull it up.
Thank you. Okay, yeah, the site that I'm looking at is page 14 of chapter 21 of the FEIR, which is AHO 88, but it's also different places.
I'm sorry, but it's also
in different places in the record. I think there's another chapter with the FEIR, the whole FEIR, but that's the site that I have.
Which page was it?
I was looking at page 14.
Looks like we're at 14.
Okay, yeah, great. It looks like the first sentence of the second paragraph is the increase in GHG emissions in average water years would be around 60,000 metric tons. I'm not reading verbatim, but but generally that's your understanding, is that right?
Yes.
Thank you. And the EIR acknowledges in the last sentence of that paragraph that that would constitute a significant net increase in GHG emissions to the atmosphere. Is that correct?
Correct. That's a correct summary of that sentence.
Thank you. And then the mitigation strategy is in 3 steps. First, on-site measures to reduce the GHGs being actually emitted by the project. Is that right? That's the first, what the authority would do first?
That's the first priority in terms of the GHG reduction strategies. There's some other components to the mitigation measure that are just kind of establishing guidelines and whatnot, but that's correct. That's in terms of the reduction strategies, that's the first priority.
Thank you. And the second priority is off-site measures that would reduce greenhouse gases from sources not necessarily affiliated with the project and not on site. Is that correct?
Correct.
I'm sorry, you trailed off for me.
I'm sorry. The second step, the second priority of mitigation is off-site measures that would reduce GHGs from sources not necessarily affiliated with the project and off the project site. Is that right?
Correct.
And the third priority is carbon credits, which means effectively paying into a fund that finances GHG reductions elsewhere. Is that right?
Essentially, I'm not sure exactly if I would, I would say yes, generally.
Thank you. If you'd like to explain how you would summarize carbon credits.
No, that's basically fine, yeah.
Okay, thank you. Could you give us an idea of what portion of the emissions would be mitigated at the first step? Meaning, what portion could be actually reduced?
Yeah, I can't give you a quantitative estimate for that. There's just, it would be too speculative at this point to, that's why we didn't include it in the environmental document. It was too speculative to provide a number.
Thank you. To get more information on that, sorry, I apologize for jumping around in these documents, but there's a chart in the EIR that shows the sources of GHG emissions as estimated in the EIR. And I think that might be helpful if we could go to the GHG chapter in the FEIR.
Which is which exhibit?
Which is AHO 88.
Great, thank you.
And if we could go to page 15. Thank you. So this is explaining the greenhouse gas emissions from various sources of alternative 1A and 1B, is that right?
Right.
And what's the greatest source of emissions on this, according to this chart? In terms of the categories on top, recreational vehicle trips, recreational boating, etc.
Yeah, the greatest contributor would be the land use change emissions.
Could land use change emissions be reduced?
I'm not aware of any methods to do that. I might pause for a moment and let Dr. Jaglow chime in, but again, I'm not super familiar with the the detailed methods and such for that analysis. So perhaps there's some way to to make tweaks or whatnot.
Thank you. Dr. Jaglow, do you have a different answer on that?
So I have seen there are new technologies with reservoirs. I believe they did it in Los Angeles where they put in those gray plastic balls on the top of a reservoir and it blocked, it reduced evaporation, it blocked algal growth, and it greatly reduced greenhouse gas emissions because basically you're like covering the top of it. And so you have no algae and it reduces emissions.
Thank you. Are you aware of any plan to do that on the site's reservoir?
I was not involved with any of the mitigation measures, so no.
Thank you. We discussed that the first priority is to reduce the emissions from the project directly. So does that mean that the authority would prioritize ways to reduce those emissions, such as the idea Dr. Jaglow mentions about the tarps?
Well, they would need to, yes, consider it, as a higher priority. However, if they can provide substantial evidence indicating that, one of the higher priorities is not feasible, and then they can move on to the next priority.
Thank you. Who determines whether a measure is feasible?
Again, I would say that's sort of beyond my realm here, because they're probably non-technical considerations that go into those types of decisions.
Thank you. So the criteria for making those decisions isn't contained in the EIR, is that correct?
Well, the mitigation measure requires that they provide substantial evidence if the priorities are not adhered to.
It's substantial evidence to who?
Well, I mean, that's kind of what underlies CEQA, right? It's I suppose ultimately it would be up to a judge if if a project were, if that were to be in consider or debated, then the ultimate decision would be, a judge would decide, well, what constitutes substantial evidence. But that's that kind of beyond my technical expertise here.
Thank you. I appreciate that. So for whatever emissions can't be reduced, the next step is offsite mitigation administered by the site's authority. Is that right?
I think so. I mean, the authority could also provide funding to another entity who would administer the specific project to reduce emissions.
Thank you. when you planned mitigation measures for the EIR, did anyone consider what offsite measures might be available?
I don't recall specific conversations, but we did come up with some examples in the mitigation measure text, such as providing solar support to residences or businesses, retrofitting or electrifying, municipal vehicle fleets or school buses. Those are a couple of the examples in the text.
Thank you. Yes. My understanding of those examples is that they're generic examples of what offsite mitigation might be, but they're not examples of local programs in the area that might be funded. Is that right?
That's right. It doesn't cite specific programs.
Thank you. Are you aware of any projects in the area that the authority could fund to achieve these offsite mitigations?
I am not, because I haven't done a thorough review of those types of programs.
Okay, thank you. And there's an order of priority for the location of these offsite mitigation programs, right? First within the project footprint, then communities in the basin, and progressively further out. Is that right?
Correct.
How far out could it include international programs?
No, the mitigation measure specifies that I'm sorry, are you referring to offsets or offsite measures?
I'm referring to offsite measures.
I believe for the offsite measures, I don't think there's a specification with regard to if those must be within the United States, but the offsets must be within the United States.
Yeah, thank you. So your understanding is that there's nothing that prevents offsite mitigation from being international. Is that correct?
That's correct. Yeah, like scientifically, it doesn't matter where a reduction occurs. GHGs are not local pollutants.
Are you aware of reported difficulty of establishing the legitimacy of international offsets?
Did you say offsets?
International mitigation and offsets, yeah.
Well, again, the mitigation measure specifies that the offsets must occur with the United States, so there would be no international offsets. In terms of offsite measures, that would be, I suppose, that could be possible. However, there's a long list of priorities, right? And each step, the authority would need to show substantial evidence that the higher priority cannot be met. So I would think it's very, very unlikely that there wouldn't be feasible projects somewhere within the United States.
Thank you. And again, your understanding is they would have to show that with substantial evidence to a judge. A judge would evaluate that?
No, I was speaking generally.
Okay.
This from my, I'm not a generalist in terms of CEQA, but my understanding is that if there's, for projects that are contested, a judge ultimately decides what's substantial evidence.
Are you aware that the CEQA process for this? Never mind, I won't ask that question. Thank you. For any mitigation measure under step 2, so off-site mitigation, would the reductions need to be real, additional, permanent, quantifiable, verified, and enforceable?
Objection compound. And lacks foundation.
With respect to which part? Mr. Ferguson?
She listed off like 6 variables, so they're all linked together.
Will you try again, Ms. Tinney?
And we haven't
can-
discussed
yeah.
any of these terms, so I
Okay. Isn't it true that offsets would have to meet a number of criteria that include that they be real?
That's correct.
They would also have to be additional?
Correct.
And would they have to be permanent?
Yes.
Would they have to be quantifiable?
Yes.
Would they have to be verified?
Yes.
And they would have to be enforceable.
Yes.
And that's true for offsets. Based on your understanding, do off-site mitigation measures have to meet those same standards?
Those definitions are specific to the California Health and Safety Code, specific to offsets. I'm not aware of any similar code that specifies those types of standards for mitigation, like the same variables that we just went through.
Thank you. So you're not aware of a code that requires those, but does the EIR require that offsite mitigation meet those standards?
It does not specifically require the either on-site or off-site measures to meet standards that were defined for GHG offsets. I wouldn't expect that to be the case.
Thank you. Do you have any experience administering or monitoring off-site mitigation programs?
I would say no, not for off-site mitigation programs.
Thank you. Dr. Jacklow, do you have any experience administering or monitoring off-site mitigation programs?
I do not.
Thank you. I want to discuss a section of the GHG EIR, the GHG chapter of the EIR, which is AHO 88, which I believe is the document that we're in, page 26. Thank you so much. This paragraph mentions that a third-party expert will be involved with review and approval of the annual reports that monitor GHG mitigation. Is that correct?
Correct.
Do you know I'll start over. Who determines when no more offsite mitigation measures are available and it's time to move on to step 3, carbon offsets?
Sorry, carbon offsets, is that what you said? Carbon offsets?
Yes.
Thank you.
I would think that would be a discussion between the authority and the third-party expert, perhaps, and they would go over those factors.
Thank you. And is there any minimum percentage requirement requiring a certain percentage of the emissions to be mitigated by offsite mitigation before moving to offsets?
No.
Thank you. So once the authority and the third party expert have decided that it's not possible to reduce the emissions any further and no more offsite mitigation is available, then they would mitigate the remaining emissions through carbon credits. That's correct?
Correct.
And once that has happened, once they've decided that they've exhausted step 1 and 2, then do they buy carbon credits for all future emissions for the life of the project? Or would they still look for opportunities as they arise to reduce emissions or conduct offsite mitigation?
So the authority and or the third party expert would assess emissions in 5-year increments for operations. So they would do it for a 5-year chunk at a time. So if for one period they use offsets, that doesn't mean that they can use a different strategy for the next period that's evaluated.
Thank you. So during every 5-year reporting period, they would start from the beginning with the prioritization of reductions and then offsite mitigation and then offsets.
Yeah, I believe that's my understanding of the measure. They would, they would evaluate, emissions for the upcoming 5-year period and see what strategies are available for reducing those emissions.
Thank you. And do all the offsets used for mitigation have to be approved through CARB?
I might have missed the word you said after CARB. Was there another word?
Oh, protocols?
Oh, protocols. The offsets have to be functionally equivalent in stringency to approved CARB protocols.
So not necessarily through approved CARB protocols, but functionally equivalent?
That's right, yeah.
Who determines if the protocols are functionally equivalent?
That would likely be the third party expert.
Thank you.
May I clarify, are you using CARB in the all caps CARB or just as the lower short of CARB?
All caps, thank you. The California Air Resources Board.
Thank you.
And Ms. Tinney, let's do a time check for today, or well, for the rest of your cross-examination. How much time do you think you have left?
I would say 10 minutes.
Well, we can,
which is the amount of time.
So let me pause for a moment. We'll see if we can get through the end of it. But here's what I want to do, because I do think I wanted to circle back. It was important to circle back. And I appreciate your patience. To Mr. Busher or any other of the attorneys who can answer whether we have a confirmation on October 29th as an acceptable additional hearing day. I did want to make sure we return to that issue.
Sorry, I was muted. Thank you, Hearing Officer Kenzie. The 29th this afternoon, mediation got scheduled for the 29th that I'm involved in, that involves DOJ and the state of California as parties as well. So I have very little control over that. So we would prefer the 4th, and I've confirmed that the 4th works for Dr. Rosenfield and me.
Okay, let's see. And I think I had confirmed that the 4th was a possibility. Yes. Are there any other known conflicts at this time with November 4th as our final, hopefully, final wrap-up day for cases in chief? Ms. Johnson.
Right, coming off of mute. Not about the scheduling, but I didn't speak up earlier, and I just did want to mention that I do expect that the state water contractors will have some cross of the NGO witnesses, possibly a short amount of cross with panel 1 on Monday. I'm hesitant to give an estimate because Ms. Jenna Mandel-Rice will be handling that for the contractors, but I expect it to be brief, but just wanted to have that on your radar.
Great. Thank you. I appreciate that. All right. So my intent is I will go ahead at an appropriate time and issue another amended hearing notice to include November 4th. I may do that. I'll get confirmation, but keep your eyes peeled as to whether or not we take the in-person portion of October 2nd off calendar. That's a possibility where we would just continue on Zoom. And I will try to do those two things in conjunction. So with that, are there any other procedural issues we need to address today? Otherwise, I'll hand things back to Ms. Tinney to forge forward until 4:59 p.m. if must be. All right, back to you, Ms. Tinney, please.
Thank you so much. Trying to remember where we are. Do you have information or research on the physical efficacy of offsets?
Physical efficacy. I'm not sure I understand what you mean by that.
Information on the efficacy of offsets.
Well, and I'll provide a response, and then I think Dr. Jaglo might have some to add, but the offsets that are used for CARB's purposes are verified to actually reduce emissions. So, my understanding is that those are the reductions that CARB shows on, the offset quantities that can be used for CARB purposes are, solid and can be assumed to actually result in the reductions.
Thank you. Do you know of examples of offset programs that have been able to demonstrate successful offsets on the scale of tens of thousands of tons of GHGs?
I would say yes, the CARB cap and trade program.
Thank you. In your opinion, is the CARB cap and trade program one of the best examples of an offset program on a large scale?
I would say so, yeah.
Thank you. Thanks. Yeah, I think I'm happy to be done here.
Thank you, Ms. Tinney. You were faster than expected.
Yes.
We're not going to start anything new, but because I have the chance, I will look to the NGO coordinating parties. Are there additional questions? Do any of you also have questions for this panel? Mr. Busher?
I mean, maybe 5 less.
Minutes, that is, or questions?
Oh, less than both, hopefully.
Okay. And Mr. Schuth?
No, I have nothing. Thank you.
Okay.
And Ms. Mertz may have some.
Ms. Mertz.
Hi, Ms. Kenzie. Yeah, I do anticipate I'll have some questions. I don't anticipate more than about 10 minutes, though.
Okay, thank you. So we'll go. We can start with you in the morning. No, not. Yes, in the morning on September 30th, Ms. Mertz, and then Mr. Busher, and then we'll go from there. Are there any other issues we should address before we adjourn for the day? And I will see you. The plan is to reconvene on Monday, September 30th. Well, thank you. Thank you to all. Yes.
Sorry, I was just going to say thank you for accommodating my and Dr. Rosenfield's scheduling difficulties. It's greatly appreciated.
Sure thing. And thank you to all of you for your professionalism. Thank you to our witnesses. And I will see you on Monday, September 30th at 9 a.m. We're adjourned for the day. Thank you.
You.